motion, item number 1.
Heard MS so the learned counsel for the petition. This application has been filed under Article 226 of the Constitution of India, challenging the detention orders passed by the state respondents under the National Security Act 1980. Stop. The petitioner is the wife of the detainee. Stop. The petitioner has impugned the order dated 26/7/2022 passed by the district magistrate, Kohima, Nagaland, detaining the detainee under section 3, subsection 2 of the National Security Act 1980. The order, the order dated 7/8/2023 passed by the Chief Secretary to the Government of Nagaland, approving the detention order of the district magistrate and detaining the detainee for an initial period of 3 months with effect from the date of detention till 25/10/2023, and the order dated 14/8/2023 issued by the Chief Secretary Nagaland, by which the representation submitted by the petitioner is rejected. Stop. Issue notice to the respondents, returnable within 4 weeks.
His Lordship, I'm appealing for 1 to 4 in the capacity of government advocate, that is PP, which 1 to 4.
Yes, Mr. Gauhati.
Here, no representation has been submitted for union.
So are you for the union number 5?
Yes, union has been made a party.
Yes. Since MS Libika, the learned government advocate, appears for the respondent number 1 to 4, and Mr. Yangarwati, the learned CGC, appears for the respondent number 5. No formal notice need be issued. Stop. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned counsel for the respondents within a period of 3 days from today, listed accordingly.
For admission, item numbers 2 to 35.
But Mr. Lordship,
Yes.
Lordship, I pray this matter come up on Wednesday, since my seniors indisposed today.
Yes, ma'am.
Your Lordships, I have no objection to that, Lordship.
Okay.
But Lordship, I must commend the benevolence shown by this honorable court in monitoring this case, taking cognizance of these cases, Lordships. And also from the inception, since 2021, this court has been very patiently monitoring the construction of Nagara Medical College, and which is today and has just recently has been inaugurated, Lordship.
Correct.
Lordship, but kindly allow me to just point out the one order, very important order and direction that was issued by this honorable court
Yes.
on 16/2/2021, Lordship.
Okay.
Because this series of issues that is raised in this PRS concerning to the health facilities and the shortfalls, Lordships. So if you would kindly allow me to read it, Lordships, on the relevant portion, Order 16/02/2021, pursuant to the order dated 15/02/2021, passed by this court, Mr. Reservoir Secretary, Health and Family Welfare Department, Ms. Dr. Kevachisa Medical, PD, Health and Family Welfare Department, Dr. Ayatollah Sera, General Mission Director, National Health Mission, Dr. Tika Lankamer, Joint Director, Health and Family Welfare, and Dr. John Gozal, Deputy Director, National Health Mission, are present before this court to advise the court about the latest development in all these matters. In this bunch of petitions, which are all public interest litigation, the common grievance is that extremely poor medical facilities in the state of Nagaland. Each petition tells the same story, although the focus is in each of these petitions will be of different districts in Nagaland, but they all reflect that the state of medical facilities and public health in Nagaland is extremely poor. There is no medical college as yet in the state of Nagaland. We have been told at the bar that 2 medical colleges has been sanctioned, one at Kohima, which medical college was sanctioned in the year 2040 with an initial budget of 1,809 crores, and the second medical college was at Mon, which was sanctioned in 2020 with an initial sanctioned budget of rupees 325 crores. Today, Dr. Tika Lankamer, who is the Joint Director of Health and Family Welfare Department, has informed this court that as far as the Mon Medical College is concerned, even the permission installed has not been made as yet. Regarding the medical college in Kohima, we have informed that the project has been delayed due to the delay in acquisition of land, but we have been told that the Kohima Medical College project will be completed by next year, in as much as the first batch of MBBS students are likely to be admitted in 2022-2023. We need to monitor these petitions, and in order to facilitate it in these 32 periods, we have requested 2 of the practicing advocates of this court, namely Mr. Alan Brown and Mr. Zach Kulo as America's career, and they will be under the overall supervision of the President of the Bar Association, Mr. A. Joe. The legal remuneration of the fee of the 2 practicing advocates, Mr. Arnold and Mr. Zach Kulo, shall be made by the State Legal Services Authority as per the rules. We request the High Court Legal Services Authority to release them an initial expense in case it is required. The American Security team shall prepare a 1-page synopsis of each of the PIL, which are 32 in numbers, and bear proof of the progress which has been made in all these PILs. The court expects them to be ready with these cases as we propose to have these cases on a regular basis. Registry shall extend all cooperation to the Americas team in examining the files and preparing notes in the registry only. No, Lordship, accordingly, synopsis has also been prepared and submitted. So, Lordship, it will be
But ma'am, we have never seen the 2 amicus curiae. What happened to them? We have never seen them in this case.
Yes, Lordship, the team.
Well, what is our former president, Mr. Ezra, doing? They were supposed to be under your supervision. No, it's all right, but I'm saying that we have never seen the amicus curiae in this case.
My lord, our limited responsibility was to file synopsis.
Okay,
So we
okay,
have done that.
okay.
Because standing councils are there. We have been instructed to prepare short synopsis for each.
Okay,
And
okay,
then we have done that.
okay, thank you. So, ma'am, what is
So,
to
Lordship,
be
my
done?
request is, as the synopsis has been prepared, if this honorable court would please to hear the case, or if a direction may be issued, since some matters pertain to which were filed in 2017, Lordship. So, if a status report can be given by the department concerned, that is medical department, then accordingly, if this court is satisfied, then the matter can be finally disposed of, Lordship. This is my prayer.
So, who is the counsel for the department? Mr. N. Mozui.
Lordship.
So, ma'am, let it come up on Wednesday.
Lordship.
Okay, Mr. N. Mozui is not there. Listed again on. Thirteenth.
Yes, Lordship.
13/9/2023. Please tell Mr. Mozui to be present
Lordship.
so that at least we can give finality to this case. With some directions, of course.
Lordship.
Okay? Yes.
Lordship.
Yes.
For admission, item number 26.
Yes, Mr. Santi Yamar. By the last order, I think you were supposed to, oh, you were filing your affidavit.
Yes, my lord, I have already
Yeah.
filed my affidavit of 5th. My
Yeah.
lord, I have communicated the order passed by this honorable court on 6th this month. And I'm waiting for the proper and necessary instructions from the respondent authorities. Therefore, I may be given 3 weeks' time to file my,
Mr. LP,
yes, your lordship.
we are not going to take this case lightly.
Yes, my lord.
Something has to be done.
Yes, your lordship.
We have to book those officers, those who are responsible.
Yes, your lordship. Yes, your lordship.
When was the work order allotted?
2011.
2011, and this is 2023.
And the sanction was made in 2018, your lordship. That was a gap of 16 years.
Okay, let's say 2018. But now 5 years down the line,
Yes,
we have not even started, it seems.
yet it's very serious and it be granted 3 weeks' time.
No, you instruct your these officers,
Yes, your lordship.
like you are submitting in the court. You tell your officers that the matter is very serious.
Yes,
And, unless something is done, we may be compelled to step in.
yes, ma'am.
We may be compelled to step in. Mr. Ezo, you are in this case.
Very please, Lordship. Lordship, just yesterday evening, I have been instructed to appear on behalf of the contractor, respondent number 7. Respondent number 7. Lordship, it appears from my friend, my junior colleague, that he has just received the additional affidavit just few days back. So now I have been instructed to assist the court. Now, as Lordship have expressed, the matter appear to be very complicated and serious. So
It's not complicated, see. It's not complicated. The work order has been issued by the government, sanction has been made. So what is difficulty for the contractor to start the work?
Lordship, I may be given 3 weeks time so that I'll assist the court properly. With
Yes, Mr. Ezo, we expect you to assist.
I'll assist. I'll assist.
Yes.
So, whichever way, there should be a conclusion. I agree.
Because we feel that the officer concerned should be made accountable. They should not escape the law.
After all, this is public interest. I agree. So, Lord,
And we want to come down heavily.
my Lord, on behalf of the contractor, I may be given 3 weeks time so that I'll file proper affidavit and then I'll assist the court.
Who is the contractor respondent number?
7. I have filed my proclamation this morning.
So you want to file affidavit?
Yes, very much. Additional, because they have come up with so many new facts now.
Mr. L.T. Santam, the learned additional advocate general for the state.
Lordship, if I may.
Yes.
This case has been pending since 2020, Lordship. Now they have taken time on numerous occasions.
You are also equally responsible for the adjournment. You are equally responsible.
This may be the last chance.
They have filed additional thing just few days back.
Lordship, this additional affidavit has been filed as per the direction of this honorable court, Lordship. Now, these people, they are living in remote areas. There are no proper roads.
Mr. L.T. Sankam.
Lordship.
The learned additional advocate general for the state respondents, and Mr. Azo, the learned counsel for the respondent number seven.
Yes.
Stop. Both the learned counsels, 6 for 3 weeks' time to file affidavit in reply to the additional affidavit filed by the petitioner on, you had filed your, on
5th September.
on 5/9/2023. Stop. 3 weeks' time is accordingly granted. Stop. To the, not stop. 3 weeks' time is accordingly granted to the respondents to file their reply affidavit.
Yes.
We make it clear that this is a case which is pending since
2020, my lord.
2020, and therefore,
I filed on
an
2020.
endeavor shall be made to dispose the petition on the next date fixed with the participation of all the parties.
Yes.
Listed accordingly. Okay.
March of that.
Deeply obliged, sir.
Yes.
For admission, I beg your pardon, for hearing, item number 37.
Yes, ma'am.
Lordship, on the last occasion, I had shown before this honorable court the staffing patterns of the training.
Which was the page? Which was the page? Or was it an extra paper?
No, Lordship.
In which affidavit?
In, an affidavit of the petitioners.
Which?
An affidavit in reply of.
2nd May.
Yes, Lordship.
2nd May.
Yes.
Yes.
So, Lordship,
Which page?
the page is at page 23. This is the staffing pattern for.
Yes, wait. Page 23. Ma'am, this manpower requirements?
Yes,
Manpower requirements, ma'am?
yes.
Okay. Yes, wait.
So this is a staffing patterns for the administrative setup of the IPI.
Just wait. We have so many affidavits, we may get confused. Yes.
Yes. So Lordship,
Which is the relevant page?
Lord,
Which is, what is the comparison you want to show here?
Lordship, page 23.
23,
Yes,
yes,
yes, on the left column side.
on the left,
Yes,
on
yes.
page 23.
Mm.
Oh,
Under 3.2.
No, ma'am, let us get it properly. This is name of the post.
Yes, name of the post, that is principal senior scale, vice principal, or the rank of class 2 principal and post interchangeable. Then the second column.
This is for training.
Yes, training wing, yes. Basic, namely seating capacity of the institute. ITI with 1,000 and above seats. Then the last column is number of posts admissible is 1. So Lordship, here, when there are 1,000 and above seats, there will be one principal in the grade of senior scale.
Which is that?
Number 1, Lordship, number of posts admissible, that is 1.
No, which page?
Lordship, page
23.
23, yes. Page 23, 3.1 is organization chart and administration of ITI. Then 3.2 is the staff admissible for industrial training institute. So 3.2.1 is administrative setup.
3.2.1.
Yes. Administrative setup of an ITI, technical staff. So serial number 1 is principal senior scale. Then the second column is the basic, namely seating capacity of the institute.
Basic, namely
Seating capacity of the institute.
So what you mean to say is that with 1,000 and above capacity,
Yes.
there should be a principal.
Or there will be only one post for principal.
Then what about this vice principal?
Lordship, principal senior scale vice, yes. Principal senior scale or vice principal, Lordship.
Is it
Yes.
or?
It is.
The option is not there.
Yes, but principal senior scale, as per this record, Your Lordship, we will take the principal.
So okay. How do you read column 2 with column 3?
Column 2.
Kindly explain. Column 2 with column 3. How do you read?
Principal, but Your Lordship here, the first one is principal senior scale vice principal of the rank of class 2 principal and post interchangeable. But Your Lordship, if we take this everything as a whole, Your Lordship, the number of posts for the principal or for the vice principal depends on the seating capacity of the trainees. So when the seating capacity is high, there will be more posts. But when there is less,
So that's why,
capacity,
madam,
there will be less posts.
Madam, kindly clarify this. What we mean to say is that for 1,000 trainees,
Yes.
there will be the post of principal or vice principal. Do you mean to submit in that way? Because we are still confused. That's why I'm telling you to explain column 2 with column 3.
If there is 1,000 and above, there will be one principal. But if there is 1,000 and above seats, there will be 2 vice principals.
Okay.
Yes.
If number of posts, if there is 1,000 and above seats,
Yes.
there will be one principal.
Yes. Yes.
Okay, and if second one, what is this 2 vice principal?
Yes. Two
There will be
vice-
2 vice principals.
Yes. Yes.
Okay,
yes,
okay.
Yes.
And if there are 600 to 999 seats, there will be one principal.
Yes. 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 So these are the staffing patterns that is fixed by the training manual for.
Okay, ma'am. Come.
So, Your Lordship, even these staffing patterns for the ITI are fixed by the Director General of Employment and Training. That is at page 15,
Page?
15.
Yes, please.
So, Lordship, on the last occasion, I had submitted one loose sheet.
Huh.
That is, it says that if there are 3,000 to 7,000 seating capacity in a state, there will be one post for joint director.
Where is that loose sheet? This is the problem. See, loose sheet, we don't know. It is loose, so it has gone somewhere. Where is that loose sheet? Is it a continuation of some documents?
It's just
That loose sheet is a continuation of some
It's
documents?
just that, it will be in continuation of this training manual, but they did not
this-
annex it, so.
But this is not a part of your annexure.
No, because Your Lordship, the one which I have shown right now, that is at page 23, that relates to the institute. Relates to the institute. But the one which I have submitted on the last day, that relates in the directorate,
Employment wing.
not in under the directorate. The training wings under the directorate. So when there are, if there are one for 3,700 sitting.
Oh. No, are you reading this National Employment Service Manual? Is that the loose shit?
Lordship. Appendix 2, norms for staffing patterns at the directorate.
No. Yeah.
Lordship, I have only one piece.
See, how do we actually like
This is craftsman training. This should be employment law. This should be a part of this craftsman. It's an appendix. I don't know which appendix it is.
is it appendix 2?
Yes, appendix 2.
Which appendix to?
Which part of the record?
It's an appendix 2 of the
Who's step?
for the ITI, Your Lordship.
Which part of the document?
It will be, Lordship, part of this page 15 of the training.
The page 15 of what? Affidavit or what?
Lordship.
You take us to the affidavits, you actually properly guide us to the pages.
I will leave this submission, and I will come and show the staffing patterns of whatever is in the record.
Okay.
So, Lordship,
Yeah.
I've shown you the staffing patterns of the training wing. Now come
Okay.
to the staffing patterns of the employment wing. That is at page 32 of the same affidavit.
Of the same affidavit.
Yes,
Page
32.
32. National Employment Service Manual.
Yes. So this is a National Employment Service Manual. The staffing patterns, Lordship, may come to page 39. The last line. Organization and structure of the employment service in the states. So, Lordship, I may be allowed to read.
Yes, wait.
Page,
Yes.
yes, organization and structure of the employment service in the state. The next page, page 41.16.
Page 41 point.
Point 16. The state director will be at the apex of the organization in the states. In larger states, he will be assisted by an additional director who will also deputize for him. The state directorates will have adequate administrative and technical staff to ensure efficiency in performance and timely collection and publication of data. The State Directorate will also function as a manpower organization and planning agency for the state. Further, it will provide leadership guidance and expertise in such technical fields, in the technical fields. So, Your Lordship, the rest are, these are also the staffing patterns that are fixed by the director, by the National Employment Manual, issued by the Ministry of Labor and Employment Director General of Employment and Training.
Employment. Training. Earlier training, no? Training. Now employment. You cannot have it. It's up to the principal now. But the difference is there. Up to the he's trying to serve it's up to the principal. And the training
In the service rule, is it not up to the
director is for director is there, but it is
in the schedule, it is only
for
the director.
deputy director of training. This is what they are writing. What's he trying to say is in the training meeting, the study pattern and from as well as government of India. So it's up to the principal.
Principal.
Cannot be up to the but then it's so if it is more than 300, 1,000, it can be up to additional director. In the manual itself. So what's he saying to the higher is below, I mean, what is the below 1,000? It can be up to
The training.
yes, not more than that. But in blue programs, it's up to the deputy director. That is, I think, what I understand for.
Yes, yes.
So, Lordship, in comparison, to make a comparison with the training wing as well as the employment wing, these two cadre, Lordship, even the staffing patterns are fixed by the Ministry of Labor and Employment. So it is not equal. The staffing pattern, everything is different, Your Lordship.
You'll just ask.
Then, Lordship, regarding with the
Yes, ma'am.
Lordship,
You said why you were showing for capacity of less than or 1,000,
yes,
the post can be up to the highest post can be up to the principal only.
yes, in the institute, yes.
Then entire department
Yes.
for entire department.
For the institute, Your Lordship, if the institute has 1,000,
Say up to 1,000
yes,
capacity.
yes,
Principal
yes,
is the highest.
in the institute.
Yes.
And if the number is higher than that, there will be deputy director. Higher than that, there will be a joint director, additional
Additional
director,
director.
like that. Yes.
Yes.
So at present, we have only in Netherlands we have only 1,292 seating capacity.
Okay.
The reason why we have less seating capacity is that
Therefore, the post is up to deputy director only.
yes, Lordship, that is the crux
Yes,
of the
sufficient,
case.
yes.
Yes. Otherwise, if the trainees are coming in, Your Lordship, there will be more posts. But the trainees are not approaching to take the skill development, Lordship. For that matter, the posts cannot be created or enhanced. So, Your Lordship, this is I've shown the staffing patterns of the both the two. Now come to the roles, the function which they are supposed to perform. That is at page.
Roles, I think you have shown us. Other.
Lordship, yes. So even the role is also totally different. So
Then why you have this having a one department of both the wings?
Lordship, initially they were placed under the.
Why don't you have a separate department?
Lordship, that is Lordship. So for that matter, the government also they have sent a letter to find a feasibility
Okay,
for
then.
the bifurcation of the department. But till now, nothing outcome is there, Your Lordship.
In essence, by your submission, they are totally different. The roles, duties, responsibilities are different.
Yes, Lordship.
So they have no connection.
No
So
connection, Lordship.
then the government has all. It is the government who have amalgamated both the.
But Lordship, it's like
There
this.
must be some logic behind it.
But Lordship,
How this can be
Yes,
I
yes.
mean, one department.
why? Because prior to 2005, there are only two ITIs. So when there is only two ITIs, the ITI cannot stand on its foot alone. For that matter, they were placed under the administrative control of the Employment Exchange. And only after 2005, there was 5 ITI were set up, Lordship. So there is a very less number of ITIs. So my learned friend has been saying that these two are co-equal and they have been discriminated in the promotion avenue, citing so much that persons who are very much junior from the employment wing have superseded them, Your Lordship. But when these two wings are differing, Your Lordship, whatever is happening in the other wing, the petitioner cannot claim comparison or claim equality based on that wing, Your Lordship.
But, madam, kindly explain this, whenever actually like officers from the training wing,
Yes.
they are actually like, they retire. Then the officers from the employment wing takes over that post.
No, Lordship. No.
That is what actually
Rather the petitioner number one who withdrew his petition, Lordship, he is the one who is occupying the post of the employment wing in the capacity of joint director.
So you have given.
Yes, we have given. Yes, we have given. So petitioner cannot say that their posts the employment wings are occupying. No, rather it is the employment training wing who had occupied the post of joint director meant for the.
So is it a charity?
So, Lordship, my prayer is that
You are also, the government is also not very stable with its action.
Yes, exactly. That is.
Government is also not very stable, so there is certainly bound to be confusion amongst the employees.
But just because the government is lenient or favor to somebody, doesn't mean that the petitioner can take advantage of that, Your Lordship.
Well, you are opening that scope. You are opening that scope for the petitioner to argue on that line.
So here, Your Lordship, the employment wing, that is executive in function, and the training wing is technical in function. So the service rule, that is the Nagaland Employment and Draftment Training Service and Nagaland Subordinate Employment and Draftment Training Service Rule, 1998. This is consciously and reasonably.
Let us see that rules once again. Let us see that rules in which I think it's in petition.
Yes,
It's in the petition.
Page 63.
Page
63.
63. Let us page 1984.
1998.
1998, page 63.
Yes, of the repetition.
Yes, page 63. Now, yes, madam, kindly come to page 66.
Yes. Lord.
Now, you can kindly explain this to us. Because actually, as per this schedule, both the employment wing as well as the training wing, they have the scope to go up to director. If we are to actually see the schedule. You see the director, +1 selection grade, then the 2 wings comes,
Yes, Lordship.
and then the director is there at the helm. So what is actually the intent?
Lordship, we have to see the schedule. This is what they have.
No. We have understood the other schedule.
Yes.
But if actually the state wanted the training wing to come up to only the deputy director, to come up to only that rank, then what is the purpose of actually giving this schedule? Constitution of service. Where actually the training wing has also scope to be promoted up to director.
As per this one, but Your Lordship, the constitution of this service under Rule 3 has to be read in accordance with the schedule, Your Lordship. So when this is mentioned, but in the schedule, it has mentioned very clear schedule,
By reading this only, the petitioners are agreed.
Lordship.
By reading together with the
Yes.
constitution and the
So now, the classification which we have to explain, Your Lordship, how they are classified from this group.
You explain.
Yes. So, Your Lordship, the classification why is based on the nature of the works, on the role that are performed, and on the
Okay, ma'am, just kindly clarify one thing. This Rule 3, Constitution of Service, correct?
yes.
And your schedule, which schedule?
Lordship to schedule 1A,
Schedule 1B.
1B, yes.
1B.
1A and 1B, we have to read.
Okay. Whether this Rule 3 has to be read together with Schedule 1A and Schedule 1B, or whether this Rule 3 has to be read only with 1A in exclusion of 1B.
It will be
See, this is the confusion we are now
It will
having.
be read in exclusion of 1B, Your Lordship.
Why include then 1A?
Lordship.
1A.
1A, it pertains to the employment wing, and 1B pertains to the training wing.
That's why,
So the training
as
wing.
per Rule 3,
Yes, yes,
this is for both employment wing and the training wing. And as per Rule 3, even the training wing has the scope to be promoted up to the director.
yes, yes.
Why actually omit that in Rule, in Schedule 1B? Why omit that scope?
Because
This is, see, ma'am, we are not against anybody. We are actually confused.
no,
And it is the government who is confusing us more and more.
Lordship, as I've stated earlier, why there is no mention of joint director in 1B, the reason being that there is less number of seating capacity in Nagaland.
Whether in the rules you have stated that,
That we have not mentioned, but the department comes under the concurrent list. So we follow the service rule, at the same time we follow the guidelines, the notification that has been issued by the central government. So the petitioner, they are challenging only the service rule. They have never challenged the ministry.
And Schedule 1A, Schedule 1B. But that can be read differently, separate.
It has to be read together.
It has to be read together, that is
When
what.
they say this deputy director or deputy director or understood that that's the
Regarding the training,
capacity and all. Therefore, they have fixed up to the.
you keep note of that. So
Yeah.
I think that is the crux
Because
as to whether one could not.
that has to be.
okay, ma'am.
Yes. So, Lordship, the rule is consciously and reasonably framed. And the classification is based on the nature of work, the role, and the function, which these two are totally separate. So, Your Lordship, for the post of joint director and above, it entails higher responsibilities and administrative also. For that matter, they have to formulate the various policies in consonance with the central ministry, Your Lordship. So the rationale behind this for the exclusion of the training wing, which is purely technical, from that of the employment, Your Lordship, is to achieve the administrative efficiency in the state, in the state, and also for discharging the public service in terms of the business that is allotted to them, Your Lordship. So they are never equal, they get not on the same footing, Your Lordship. So these two are separate wing. So the service rule, Your Lordship, there is no violation of Article 14. Petitioner,
But if these two wings are totally distinct and different,
yes, Lordship,
what is the question of classification?
Lordship, because what the petitioner
You
is,
said-
yes,
You said responsibility,
Yes.
duties, totally different.
totally different,
Distinct.
totally distinct.
No question of classification.
So, no, from the post of joint director and above, because what the petitioner is challenging the service rule, saying that it is the same,
Classification,
class.
classification will apply
Yes,
when there is equal.
Lordship,
Correct.
Two things are equal, then you may have a power to an authority to classify. If they are not equal, where's the question of
yes,
classification?
so Lordship, they are totally
Somewhere
different.
they have to be equal.
Yes. So they are not equal, and they are claiming that they have been discriminated, and there is unequality treatment given among the equal. So, Lordship,
Why, ma'am, why don't you advise the government to let this two wings be a separate department so that actually at least there can be no heartburn?
that too, Your Lordship.
You put them in one department and then you differentiate them into two classes. You give one class a better scope for promotion. The other scope has less chance of promotion. So the wing having the less chance of promotion will definitely have heartburn and come before this.
Of course, Your Lordship, they may have some grievances, but Lordship, unless they challenge the ministry guidelines, Your Lordship, and when the number of posts, the number of everything has to be based on the seating capacity of the ITI. So where is the question of bifurcating or creating a separate department for them?
No, rule is under challenge.
Yes, Lordship.
It is your bounden duty to clarify and justify
Yes.
the recruitment rule. And they are not supposed to challenge the notification, whatever guidelines. You have followed the guidelines. Accordingly, you have to clarify and make a recruitment rule, frame a recruitment rule in consonance with that. It is still confusing. You have brought something, we have understood
Yes.
what I'm trying to
Otherwise,
argue, but then
Lordship, in
your
actuality-
rule has
Yes.
to be framed properly.
Yes. In actuality, also, even in the ministry, central ministry, these two are separate department. Only in the state of Nagaland, this work was brought under the administrative control of the employment exchange.
Because this, when you read Rule 3, you said, rightly you said it has to read along with the settle.
Schedule 1A.
So first you have to overcome this Rule 3. The main, the Rule 3,
So,
settle comes thereafter.
yes. So there may be some typing mistake may be there, Your Lordship.
No.
I haven't missed it.
No,
Don't-
suppose.
Don't take that step.
Yes, Lordship.
So far as the rules are concerned, please don't take that step.
That one is consciously framed. So, Your Lordship, it has to be read in consonant. A provision might have been given, Your Lordship.
You file an affidavit to that effect in that case. There is a typical
No,
mistake,
Lordship, and
typographical error.
Lordship, a provision might have been placed, set up, if there is a number of seating capacity increases in future. But that has to be read in consonance with the Schedule 1A.
Are you submitting that this court has to read down the Rule 3? Is it your case?
Lordship,
Read down the Rule 3.
Read down Rule 3 in exclusion of Schedule 1B.
Yes.
to read.
That is what is confusing us.
Okay, Lordship.
The Rule 3. Rule 3 That is why I have been repeatedly actually raising up this issue.
Yes.
Rule 3, if you have to actually read Rule 3, it has to be read with Schedule 1A and 1B.
Lordship.
Why actually take only Schedule 1A and exclude 1B?
Yes.
That is the confusion we are having.
So, for that matter, I have explained that we follow
The
Central
guidelines.
Ministry- Yeah,
The
guidelines. Where there is a less number of sitting capacity, Lordship, there cannot be a post of joint director, higher post. The staffing pattern, all those things are fixed by the ministry. For that matter, Your Lordship, in Schedule 1B, the post of joint director has been omitted. It's not in the schedule.
But you have given joint director promotion to the
So, Your Lordship,
training wing.
the training wing, he is occupying the post meant for the employment. Lordship, I may come to page 60. I'll show you, Lordship. So how he is occupying the page 86, Lordship.
Once, madam,
Yes, Lordship.
once you have given all that benefits through the training wing, it will be very difficult to come out of that.
No, but this one is in violation of the this service rule, Lordship.
That's the
doubt-
government.
No doubt the state, we did a mistake. No doubt, Lordship, it is supposed to be given to the employment wing. We have given to the training wing. But just because of that, he cannot take an advantage and claim his right on the basis of a wrong mistake.
But can you disown this order?
I'm saying that.
Is it by you only?
It is in violation, Lordship, though it was in violation of the service rule. Page 86, Your Lordship. Engineer Wati, he is appointed against the vacancy of Sri M. Liwang Konyak, promoted and retired, Lordship. So who is Sri M. Liwang Konyak? Lordship may come to
We're not
see.
concerned. You have passed this order. It is your documents only.
So my lordship has posed a question on me saying that we have given a promotion to petitioner number 1 and he is occupying the post of a joint director. So I'm showing that that post is meant for employment wing, not for the training.
So you
See.
recall this order?
See, madam,
He already withdrew himself from the case.
see, if we read this order, 18/10/2019, if we read this order conjointly with your Rule 3, if we read this order, page 86, conjointly with Rule 3, it strengthens the submission of strengthens the submission made by the learned council
But
that the Rule 3 has to be read in, the Schedule 1 and 2 has to be read in consonance with Rule 3.
no, then it has to be read, Your Lordship, against what post, against what vacancy the petitioner is occupying. We have to say, because he is occupying against the vacancy of a person of M. Liwang Konyak. And who is M. Liwang Konyak? From which wing he has come, Your Lordship? So M. Liwang Konyak is from the stream of employment wing.
You clean up your house. You were the one who has dirtied everything.
So, Lordship, now I'll place one citation and I'll go. Lordship, my citation is.
Government submitted written argument in support of this justification. Plus, no? Yes, correct.
Okay, man.
Lordship, 2002 for ACC 34.
234.
Yeah, 34.
34.
Yes. 2002 for ACC 34. Lordship, it's Ashutosh Gupta versus State of Rajasthan and others. Lordship, may come to page
Para.
para 5, page 41. Para 5, page 41. Sixth line from the bottom.
Page 41.
Page
1,
41,
2,
fifth
3,
line, sixth line from the bottom.
7.
Sixth line, where the challenge is made.
It's 7.
Okay, Lordship. Where the challenge is made to a statutory provision being discriminatory, allegations in writ petition must be specific, clear, and unambiguous. There must be proper pleadings and averment in the substantive petition before the question of denial of equal protection of infringement of fundamental rights can be decided. There is always a presumption in favor of the constitutionality of enactment, and the burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principles. The presumption of constitutionality stems from the wide power of classification which the legislature must of necessity possess in making laws operating differently as regard different groups of persons in order to give effect to policy. It must be presumed that the legislature understands and correctly appreciates the needs of its own people, that its laws are directed to problems made manifest by experience. The claim of equal protection under Article 14 therefore is examined with the aforesaid presumption that the state acts are reasonable and justified. If we examine the challenge to the impugned provision from the aforesaid standpoint, we have no hesitation to hold that the applicants have utterly failed to establish any material from which grievances about the discrimination alleged can be said to have been made. 6. The concept of equality before law does not involve the idea of absolute equality amongst all, which may be a physical impossibility. All that Article 14 guarantees is the similarity of treatment and not identical treatment. The protection of equal laws does not mean that all law must be uniform. Equality before the law means that among equals, the law should be equal and should be equally administered, and the like should be treated alike. Equality before the law does not mean that those things which are different shall be treated as though they were the same. It is true that Article 14 enjoins that the people similarly situated should be treated similarly, but what amount of this similarity would make the people entitled to be treated equally is rather a vexed question. A legislature which has to deal with diverse problems arising out of an infinite variety of human relations must of necessity have the power of making special laws to attain particular objects, and for that purpose it must have large powers of selection or classification of persons and things upon which such laws are to operate. Mere differentiation or inequality of treatment does not per se amount to discrimination within the inhibition of the Equal Protection Clause. The state has always the power to make classification on a basis of rational distinctions relevant to the particular subjects to be dealt with. In order to pass the test of permissible classification, two conditions must be fulfilled, namely, 1, that the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others who are left out of the group, and 2, that the differentia must have a rational relation to the object sought to be achieved by the act. What is necessary is that there must be a nexus between the basis of classification and the object of the act. When a law is challenged as violative of Article 14, it is necessary in the first place to ascertain the policy underlying the statute and the object intended to be achieved by it. Having ascertained the policy and the object of the act, the court has to apply a dual test in examining the validity. The test being whether the classification is rational and based upon an intelligible differential, which distinguish persons or things that are grouped together from others that are left out of the group, and whether the basis of differentiation has any rational nexus or relation with its avowed policy and object. In order that a law may be struck down under this article, the inequality must arise under the same piece of legislation or under the same set of law which have to be treated together as one enactment. Inequality resulting from two different enactments made by two different authorities in relation to the same subject will not be liable to attack under Article 14. It is well settled that Article 14 does not require that the legislative classification should be scientifically or logically perfect. So here, Your Lordship, it's clearly covered my case. So that's my prayer, Lordship.
Madam, what in sum and substance, what you meant to submit is that actually denying the higher post of a joint director to the training wing is in view of the guidelines laid down by the central government.
Lordship, yes.
Let us note down that.
Much better.
Yes, thank you. Mr. Ezo, you are for respondent number?
5 to 16.
Five minutes more. 5 minutes more. 11:30.
Okay.
Okay.
We will just take a 5 minutes break. Yes, Mr. Joe.
May I please, Lordship,
Yes.
on the last occasion, Lordship must be remembering my undertaking that I would try to finish in 30 minutes.
We were just discussing that.
My Lord, but it appears that there is some confusion in the minds of the Lordship. So I may take little more time to
Very good, very good. Okay,
In a very humble way, I'll try to
Okay,
satisfy Lordship and clear the confusion.
very good.
My Lord, before I open my affidavit and my document, I'll just
Yes, give us the gist.
yes, just
Give us the gist of your case.
Yes, madam.
Yes.
My Lord, these two different cadres, employment wing,
Can you call them cadre or wings?
very much different cadre. I can
Different cadre. Okay, good.
two different cadres, therefore two separate channel of promotion, seniority, everything. Also, two different cadres. Both are the employees of the Nagaland Employment and Craftsman Training Service Directorate. And my Lord, there is a service rule called 1988 governing the terms and conditions of the services of all the employees, including border cadres.
1988. 1998.
My Lord, 1998. So the terms and conditions govern all of us. And today, after more than 23 years, they have come before a court challenging the rules framed under 309 of the Constitution of India. My Lord, there are few points to be considered by this honorable court as far as this case is concerned. I'm not going to the facts of the case because this is pure, I believe, in my humble submission, this is pure question of law, challenging the rule. So facts, according to me, facts may not be very relevant. So I'll purely dwell on law, question of law, my Lord. My Lord, the first question would be, this honorable court might like to know, the first question is whether the rules can be challenged in this manner. One. Two, whether the two different cadres had really been merged. Because several times in several pages they have used the word merger. So that is one second consideration Lordship may like to consider. The third question will be whether the two different cadres are equal or not. Equal or not. Two different cadres. Employment wing, training wing, they are equal or not in the eye of law, in terms of the rules. Three. My Lord, then next is whether the two different cadres have same qualification or not. The qualification we call it, that is called intelligible differential. Whether they have different qualification or same qualification, that is another consideration, while considering this case. Then, my Lord, the next consideration would be whether the two different cadres have same functions and duties or not. Another consideration, based on the rules, whether there are two seniority lists maintained till today, two seniority separation for two different cadres. Third, next is whether they have ever challenged such seniority if they agree. Not done. So these are the few considerations. And I'll come to the other part. So now in my humble submission, verbally I'll just try to present the case in a simple way. To challenge the rules, the statutory rules framed under Article 309 of the Constitution of India can be challenged on two grounds only,
Correct.
One is if the rule is constitutionally invalid, meaning if there is any violative of Article 14 and 16, where is it? They have to prove. I say there is no violation. I'll certify it.
Part 3.
Number two, if the rule is ultra vires, but that ground I have not taken. Ultra vires means action done beyond one's legal power.
Yes.
They have no question the power exercised while framing the rules.
The legislative competence.
Yes, my Lord.
Correct.
So one of these two grounds, one is whether the rule is violative of the constitutional validity?
No, there is one more.
Yes.
Latest one more ground has been added.
Yes. Okay.
Anyway,
Arbitrary.
Yes. Now, the first ground is that validity, so rule should be constitutionally valid. Invalid, constitution invalid. If that is so, then they have to prove. Now, in the present case, there is no violation of Article 1460 in my humble submission. I'll satisfy the court. The next ground is these two colors.
That has been latest added by the Supreme Court.
Yes, yes.
May I continue?
Yes, please. Yes.
These two cadres had never been merged as the petitioner has stated in paragraph 3, 5, and 6 of the petition. They have repeatedly said that this is a merger. Then where is the principle of merger, doctrine of merger? Now, there is no merger. In fact, it is a misrepresentation of facts. This training wing, ITI, Industrial Training Institute, was an orphan in the state of Nagaland. It was under education department in the past, before 71. It was called Polytechnic under education department because it cannot have its own separate directorate. Then after 71, since there was no one to adopt them as adopted son.
Okay.
So after 71, this training institute, because my lord will appreciate the nomenclature of institute, just to train the trade inspectors, tailors, workshop wallahs, knitting helpers. So the institute has to be under someone's care. So after 71, this institute was brought under the labor ministry in the state of Nagaland. Labor employment. Labor employment.
Correct.
Then finally what happened? In 1986, I'll show the document, I'll show the annexure
Yes,
when I
yes.
come to the document.
Okay, yes.
In 1986, since there was no one to adopt them and keep them to protect them, so they had to be transferred and brought under the administrative control of the employment directorate. I'll show the document. They were transferred and brought under the administrative control. Who is the administrator? Employment directorate. Under employment administrative control of the employment directorate in 1986. I hope Lordship has cleared to that
Yes.
extent. Now thereafter that, there has been, because institute had to be run under some directorate, has to be run under some administrative function of some parent department. So after 1986, they have been with me under my control for more than 20 years now. After bringing them under the administrative control of the employment directorate.
so according to your training wing is a stepbrother.
Orphan.
Orphan. I use the word orphan.
You brought him as a
I
stepbrother.
did not bring it. State government sent to me that I must take care of them.
You must adopt.
I must nurture them.
No,
Therefore,
therefore they are stepbrothers. Stepbrothers.
No. Yes. Yes. I'm giving them shelter. I'm giving them shelter.
Okay, continue.
That is the discrimination.
Because unless we say something, court may not smile, so I'm saying all this. Yes. Because for 2 days, my letter friend, counsel petitioner, had taken 2 days
Yes.
to satisfy the court. So I thought to sum up and to make the court clear, I'm just making this submission. After 1986, they have been under my care, under the direct administrative control of the employment directorate. I'll show the document. How they have been brought. So Whereas the submission of the land council for the petitioner is merger, 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 3 times, para 3, para 5, para 6. Repeatedly. This is a clear case of misrepresentations of facts. Now next question, my lord. Question of equality. Whether the 2 different cadres are equal or not. I say never. They keep saying if we go to the paragraph of the writ petition, equal, equal, equal. How comes? I was wondering how could they say the equal when document shows otherwise? When the service rule shows otherwise, I come to service rule. I satisfy lordship. Why it is different? How it is different? When the 2 cadres are not equal, how can they claim the same benefit? They can ask equality from among their own staff. If a junior from the training wing has superseded the senior, question of equality comes. Here, 2 distinct different cadres, therefore they cannot encroach upon my jurisdiction, nor I can also. This is clear. We must. In my humble submission, I want to make it clear. Now, why I say these 2 are different? Why they are not equal? Number 1. Entry point is different in the case of class 2 gazetted. Started from class 2.
What is different?
Entry point.
Entry point.
Entry point is different, my lord. In the case of class 2 gazette, for the employment wing, the entry point for employment wing is employment official. The name employment official. Whereas in the case of the training wing, the entry point is vice principal. What is the responsibility and job of vice principal? Vice principal means to take the administrative function? No. Principal means to teach. The entry point for the 2 entry point is, one is employment official, employment wing. The other is vice principal. Where is the question of equality in the entry point? Entry point is not equal. Different entry point. Right.
You mean to say that there is no equation of post?
Nothing. I'll show from the rules. I'll show from the service.
Okay.
Right. Just verbal submission.
Yes.
So that lordship was joking and saying that you are still confused. So I'm trying to clarify.
Okay.
That. Now, so entry point, posts are different. For the employment official, for the training, since it's a teaching instructor, vice principal, then how comes that they are saying they are equal, they have been deprived, arbitrariness is their discrimination? How? Let them prove. Till now, I believe they have no proof. Because they cannot prove beyond this. They have to go by this. The post is shown here at the entry point. I'll come. Then, my lord, the entry point for the grade 4, sweeper, chowkidar, lighter, grade 3, non-gazetted. Grade 3, grade 4, the entry point is different. For the employment, technical assistant, for the training, trade instructor. Post is not equal, not same. How can they say they are equal? My lord. Then, the most important part, intelligible differential qualification. Are they same with education qualification? Do they have same education qualification? Service rule say never. No. I'll show from service rule. The different qualification for the 2 cadres is this, man. For the class 2 gazette, for the employment wing as employment official in 3 point, what qualification does a person need? Just degree from any stream. RDA.
Class 2 officer for the employment wing.
Employment wing. Class 2 official in 3 point. Employment wing, the qualification prescribed under the rule is any degree, BSc, any common, anything. I'll show the rules.
Okay.
Then in the case of training wing, for the post of vice principal, since this is technical, instructor, workshop, they have to teach. So what qualification they require? Purely technical qualification. BTech, MTech, electrical, civil engineering, only engineering qualification is required for them. Only technical qualification is required for also from the service room. Why? Because they are not going to take over the administrative function. They have to teach the student, the training instructor. In Nagaland, they have to produce many tailors. In Nagaland, they have to produce many foremen in the workshop. In Nagaland, they have to bring many drogo students to be employed with some trades. So therefore, qualification for the vice principal, for the in respect of the training wing is purely technical. BTech, MTech, electrical, civil, it is not with equivalent. For the in respect of employment, BA degree, MA, BSc degree, commerce, anything, because this is general administration, my lord. So, where is the equality? Is there any qualification prescribed, same qualification prescribed for the two? Never. They have two different educational qualifications, which is called intelligible differential. Supreme Court has already laid down the law that if there is intelligible differential, then there is no question of amalgamation, no question of merger, nothing. I have judgment. Also. Now, that is in the case of class 2 gazette for board. For the general, for the employment, any general degree from any university. For the training, technical qualification. Then, in the case of grade 4, sweeper, chowkidar, instructor, whatever it may be. In the case of employment, degree in arts, starting degree in arts, or with equivalent.
So class two and for fourth grade,
Yes.
the education required in the entry point is same.
Same, similar. Now the post for employment assistant, technical assistant. Now in the case of training wing, trade instructor, the minimum qualification for trade instructors matriculate. Matriculate is a minimum qualification for them in grade 3 and grade 4. Whereas for us, BA degree. Where is the equality? Where is the question of having same qualification? Where is the question of where is the question that there is no intelligible differential? My lord, these are the questions, these are the area.
Different cadre with different educational qualification, I think in that case.
Yes, Mr. Chair.
My lord,
Please proceed.
all the submission made above, I'll show from that service room.
Okay.
I'll not go beyond that. I'll confine within service room. Now, the next consideration for this number court is whether the two different cadres have same functions and duties. Never. Vice principal for what? To teach. Employment officials for what? The nomenclature is administrative. Now the duty, two different duties and function is employment. It's a just common sense. Common sense. For employment administrative duties, for training, teaching the trade instructor in the institute under ITI. Nagaland will show from the record. Till today, we have not even reached 1,000 trainees. I'll show from record. So now, there are difference of functions and duties between the two cadres. Now, the next question is, last question is, whether there is a common seniority list for the two different cadres. If there is one cadre, obviously there will be one same cadre or same seniority list. In the case here, from 2004 till today, suppressed seniority list for two cadres, and the promotional scope has to be on the basis of seniority maintained by the directorate. I have never challenged. obediently they have followed, no grievance. Now, therefore, at every stage, the employment wing and training wing are shown differently. Nowhere it can be said that the two different wings are treated equally, from entry point, from qualification, from functions and duties, from the everything. Nowhere it is shown that they are equal. There is no question of equals treated unequally. If their case is that we're equal, but we're treated unequally, then yes, as I said, they can come before the court challenging the constitutional validity of the rules framed under 309 of the Constitution of India. Now, when they are not equal at any stage, can they invoke the Article 2 to 6 of the Constitution of India and quash these rules? To quash this, they have to prove that there is equality, but they were treated unequally. They could not prove. Well, now, as I said, yes, they are all employees, but ITI, as I say, is an orphan without parents. So therefore, as I said, they had to be under someone's care. To the best of my knowledge, all over India, they are under someone's custody. They are under someone's protection. All over India, they are under someone's control, administrative control, because the very nomenclature, the very name itself says they are institute. So institute has to be run under someone's administrative control. In the state of Nagaland, as I said, initially it was called Polytechnic School under School Education Department prior to 71. Then in 1971, it was converted into ITI and subsequently placed under Labor and Employment Department. Now, Labor also said, they said, no, we cannot take care of you now. You have to be sent somewhere. So government decided,
Did the Labor Department say
Labor
that?
Department refused that. Very unfortunate. In fact, we should not do that. We'll not do that. We'll keep them. So long, they have their own directorate. But the difficulty to have their own directorate are shown from that report. Why they do not have directorate? Because Lordship will appreciate human approach. When trainings are not there, will this High Court orders them to create directorate and make them to spend from common exchequer?
We don't have the power.
Yes, my lord, that's what I have cited one judgment also at the end.
We don't have
Court has no power to direct the state government. I have cited one judgment, latest judgment. Well, today, just apart from this, now in the state of Nagaland, Lordship knows very well. Prosecution, they don't have directorate. But in CRPC, it is mentioned that the state government may set up directorate of prosecution. But when the scale is not there, the state government is of the opinion that it will be wasting government's exchequer unnecessarily while manpower is not there. As far as the legal system is concerned, those CRPC provide, state government may set up a directorate for prosecution. But in the state of Nagaland, not only Nagaland, many more small states, I believe for that matter, even Arunachal, that do not directorate of prosecution. Why? Even Manipur they don't have, even Assam they don't have, I believe, because practical aspect, Lordship will appreciate. Simply because there are certain illegality. High Court cannot just join into the executive power or legislative power and do something which may not be very encouraging. But this is a purely executive power, purely legislative power. So today, when the total strength of the trainees in Nagaland is 1,292. But the present trainees in entire Nagaland, I'll show the record. Entire Nagaland, 639. For
So,
600
so what you mean to say is that 1,200 is only in paper?
only in paper, because trainees don't come forward. That is the seating capacity in the state of Nagaland, classified by government. Seating capacity, this much we can accommodate. Even that also, now we are not getting the trainees, they are not coming forward. Maybe I don't know how they produce the qualities. If they don't produce good qualities, instructor will not come, workshop owner will not come, foreman will not come, tailor will not come. So till today, though the provision is made that government can accommodate 1,292, but presently not even 700. Meaning thereby, for this, Lordship have posed a question. Why don't you create a separate director? My Lord, if it is feasible, I'll appreciate this honorable call that God has done justice. But government also has to see the administrative convenient and practical aspect of a particular department, whether it can have separate.
We were just expressing that.
Yes.
We don't have that authority
My
to
Lord.
direct the government
Yes.
to create.
Lordship have understood. I have a next judgment also on that aspect. My Lord, therefore, all this now, therefore, the case of the petitioner is that we are equal, why you treated unequally? You show me. I have pointed out. Show me. Inequality, you show me. The qualification, you show me. The classification, you show me. Responsibility, you show me. Seniority, you show me. If you cannot show me, then we cannot blame the court. But we have to accept the facts. Seniority, show me. Where is the equality? Since these two separate cadres are called women, legally we should be called cadres, separate cadres. Because entry point is different, qualification is different, functions are different, in service the seniority is different. How can we say that these two separate cadres are one? I'm sorry, I said they are orphan. We have to take care of them. We have to feed them. Allow them to stay in my veranda, corridor, when they don't have their parents. A time will come. Yes, tomorrow Nagaland, if you can increase up to 1 crore population.
But as per the counsel for the petitioner,
Yes.
you are actually having the bigger share of what they are actually getting from the center.
Lordship appreciate what I'm saying. If they can, they should become separate directorate. I wish they can. I wish they should. But the quality they produce to the trainees are not coming forward to learn from them. So for that, when there is no sitting capacity, when there is no trainees to fill up the sitting capacity provided by the state government, nobody is stopping them to be with us. I wish if they can go and have separate directorate through a legislative power. But practically, it's not a job practically. Why in the state of Nagaland, why we don't have trainees? I'm going to show from the chart, Moguchuna, how many trainees, Zonebuta, how many trainees, Kohima, I'm going to show. I'll come to the document now. Why? Why people have poor impression on this institute? Why? People go to Assam and bring certificate, diploma, all this. Why Nagaland people don't want to go to our own institute, training institute? Is it the vice principal they are not teaching properly? Whether the foremen are not teaching them properly? Question yourself. Don't ask me. Never ask permission from me to go away. Go away. Go away. If you have the strength, if you have the manpower, if you have the trainings, if you can produce 1,000 trainees, I'm going to show you the manual, the capacity. Madam has shown a little bit, I'll show in detail, so that the picture will be clear to this work.
I hope, Mr. Ezo,
My Lord.
anytime in future you will not be taking up the case of the training wing. After all the submissions, one day, if by coincidence you happen to take up the case of the training wing, definitely we will remember all
My
this.
Lord, lawyers and doctors are like prostitutes. We may have to accept sometimes,
Okay.
depending on the facts of the case. Yes. But as on today, this is the correct picture. So that's why I'm trying to clear the confusions of to the decisional court, that the minds of the judges should be clear. Whichever way, I don't say I must be given relief, no, but do justice and judgment should be accepted. So therefore, I'm just trying to clear the doubt, the confusion in the minds of the judges. Now, my lord, I'm come to the rule, the guidelines, because I have said so many things. I want to show copy. This is my copy. My 2 copy. Then just copy to the page. My lord, from here I'm going to show the strength of the trainees, which the positions where the trainees from the training wing, if they want any promotion, this is direct right, my lord. My lord, I'm very sorry. One copy, we don't have hard copy, so we have given one type of Xerox copy, but the other one is hard copy. Hard copy, I draw your lordship's attention to hard copy first. Page. My lord, this is training manual for Industrial Training Institute, my lord. My lord, I believe my colleague, my junior colleague has flagged the relevant page. The hard copy, my lord, hard copy.
This appendix 2.
My actual appendix 2. Appendix 2, page 66. Appendix 2. Hard copy, my lord. Hard copy in the hard copy. Appendix
66.
Page 66. Page 66 is not in, but next is page 67.
Yes. 66. You are referring to.
Why I'm trying to show this is this, my lord. Norms for staffing pattern at directorates. Directorates, man. We are talking about directorate today.
Okay.
Directorate of States or Union Territories for implementation of craftsman training scheme. Below, my lord. Now, serial number 1, name of the post. Norms of post. Now for the post of additional director of training. For one additional training post, the seating capacity should be 5,000 to 10,000. Then number 2, for 2 additional director posts for trainees.
Yes.
My lord, that is different copy, my lord.
This one?
Hard copy, hard
This
copy.
one?
Yes, that one.
Page 67.
My lord, that we are coming to that next. We are coming to that. Then where is it? Hard copy.
Let us see the cover. These are not the same books.
No. I'm coming to that next. Next is Xerox copy have been supplied.
Yes. Have you given 2 copies of this?
Yes.
Not this, no? Okay. This is the copy of this. So,
Appendix 2.
he's reading appendix 2. Okay. Yes. Mr. Azor, we have got it.
This is the same thing?
No, this
This is the same thing which he is submitted.
Okay.
This is same
Same thing which
copy.
the learned additional AG has
I'm not
submitted.
sure.
But
She
learned
has-
additional AG has submitted only 1 page.
Yeah, this is the book. My lord, may I continue?
Yes, please.
Now, this is the norms for staffing pattern at directorate. We are talking about directorate today. Now, for the additional post of training, the seating capacity should be 5,000 to 10,000 seats for 1 additional post of trainees. Then, for 2 additional posts of trainees, the total strength seating capacity of the trainee should be 10,001 to 20,000. Then, if they need 3 additional director posts, then 1 additional for every additional 20,000 seats. Then next, joint director of trainees. or they call it controller examination. One joint director post is for 3,000 students to 7,000 students, my lord. And then there are then come to number 3, deputy director. Where on this question issue, my lord, they have deputy director till today. They have deputy director. Now, for one deputy director post for trainees, one deputy director, the total strength of the trainee should be 2,000 to 4,000 seats. In Nagaland, the total strength prescribed for by the government is 1,000 something. But the existing trainees is not even reaching 700. So therefore, even for the post of deputy director, we need 2,000 to 4,000 trainees. But in the state of Nagaland, the strength sanctioned by government also only 1,000 something. So therefore, though there is no sufficient trainees, at least they have been given one deputy director.
So the government, if the government has sanctioned one deputy director for 1,200,
Yes.
then the government is not following these norms.
Yes.
It shows that the government is not following these norms.
They should follow. But they should follow. They should follow.
No, but the government is not following.
Yeah. Less than this. Government's prescription is only 1,000 trainees. 1,292.
That's what we are saying. That the government is not strictly following this appendix 2.
They should, as I say, without sufficient strength, if we create more posts, the consequence is the government exchequer will be at loss. So government should take care of that. Now,
That detail additional AG?
yes, that's her responsibility. My lord, then this is directorate. We are talking about director, a deputy director now. Now coming to institute, training institute, where the tailors, workshop, foreman, all these are taught. Training, we have given the copy, hard copy, one copy, and one is.
This is training manual for industrial training institutes.
Yes.
Part 1, 3rd edition.
Correct.
Okay.
Page. My lord, I think we have flagged it. Page 38.
Yes, wait.
Manpower,
Page
38.
38.
Opposite is 39.
There is no flag.
Give me.
Isn't it?
Page 38. Okay.
So you may use the.
No, it's all right, brother. It's all right. So, no problem.
Page 38.
Ha.
Here I want to show manpower requirement, role and responsibilities. 1. Ordinance chart and administration of ITIs, Industrial Training Institute ITIs. Staff admissible for Industrial Training Institute. Administrative setup of an ITI. It is training institute, not directorate, but institute. Moratorium Institute, Zonabota Institute, Kohima Institute, the institute, the schools institutes. So here, what is the requirement? For the post of principal senior scale, the training should be 1,000 and above. Then below, principal senior scale ITI with 600 to 999 seats. Below. So these are the seating capacities in institute.
This ITAs.
In institutes. So now, my lord, here.
Just with
Yes.
principal senior scale. ITI with 1,000 and above seats.
Students,
1.
trainees, yes.
Principal. Why repeat it again? Principal senior scale ITI with 6,000 to 999.
They have some scale grade.
Okay. But nothing is mentioned about the scale grade.
Yes. Now, in the case of Nagaland, just to show me, I'll come to that later.
Because here actually like in this stuff admissible for Industrial Training Institute,
Yes.
serial 1, 2 and 3
Yes.
talks about the principal senior scale,
Yes.
but the intake of the students is less.
Yes.
Correct?
Yes, correct.
So we are confused.
Number of posts admissible, next column 1. One of these are the number of possible posts. If it is for principal senior scale one post in one institute in Mohokchun. To have one principal in Mohokchun ITI, there should be one principal. Supposing if there one principal senior scale in Zuleboto, they should have one.
No.
Institute.
Mr. Zo.
Yes, ma'am.
Just clarify this.
Yes,
1, 2, and 3.
yes,
It all like name of the post is principal senior scale.
yes,
Correct.
yes.
The column 3.
Column 3, yes.
Basic namely seating capacity of the institute.
Yes.
Why actually for serial number 2 and 3
Yes.
there is a decrease in the number of seats?
It's 20 years.
Why? Same principal, same post,
Yes.
senior scale, but actually for serial number 2 and 3 there is a decrease in the number of the seats.
Explanation is not given that part. Explanation is not given. But this is the chart. Now,
We understood. Good.
done. No, before that.
Same.
Principal, principal,
Yes,
Why
I'll show the chart.
reduction in the number of seats? Why?
When there is a reduction in seat, this will be added by the principal. But why this same reduction we can understand?
Correct.
Should have been a different
Different
lower
post. A little lower post.
Yeah. Why this is to a similar post as in scale? You said there is no explanation.
Mr. Ezo,
Yes, ma'am.
if there is no explanation to 2 and 3,
Yes.
you are leaving us in a gray area.
I know that. Yeah, I'm sorry. I don't have, because there's no explanation here. That's why I also have. I don't
Okay,
have
proceed, please.
Well, Lordship, if Lordship have clear about that manual, then I'll come to my affidavit and index. This is the guideline given by the central government for post creation for the ITI. Now in Nagaland, Lordship, if Lordship comes to my affidavit in opposition, page affidavit filed on behalf of the private respondent, 5 to 16.
Your-
Page 8.
Just,
Page 8.
just wait. Your affidavit of respondent number?
5 to 16. My lord, affidavit, filed by the private respondents, my lord. Page 18.
Just wait. 5 to 16?
Yes, sir.
1, 2,
First on the top.
5 to 16, this is 2nd May. 2nd May 2022. 2nd May.
23rd March.
23rd March.
23rd March. First.
Oh, affidavit
on the
in
top.
reply, okay.
On the top.
Yes.
We have stitch up like this, so it's like this. We have stitch up with the cotton thread.
Affidavit.
This one.
This one?
We have stitch with cotton.
Affidavit, this is 600. Engineer cable.
Yes, my lord, that one.
Affidavit is sworn by Mr. Sabi Visa.
Yes, my lord.
Yes, 23rd March
23rd March. Okay.
is the one.
This is just.
My lord,
You are Mr. Zo.
my lord.
You are for respondent number
5
6.
to 16. 5 to 16.
Okay.
Then, my lord, the relevant page is 18,
18.
18. I am trying to show in Nagaland the total strength of the trainees in Nagaland by this document. By this document. Page 18, they have given all different threads, name of the threads, unit wise. So these are the threats all over Nagaland. Huh? These are the different threats all over Nagaland, and the total strength sanctioned by the government is page 19, my lord, at the bottom. Ground total strength of the trainees.
Where? Ground?
Page 19.
Where?
Last bottom. Ground total.
Grand total,
This is the-
1292.
Yes. The total strength of the trainees prescribed by the state in the Nagaland. Total sitting capacities of the trainees. Total sitting capacity of the trainees in the entire Nagaland. 1,292, my lord.
Qualification,
Yes.
8 bus. Sitting
Different
capacity, 40. Sitting capacity. So the grand total would mean sitting capacity.
Sitting capacity of the trainees for the whole Nagaland for different trades, tailoring, shoemaking, workshop wala, all this.
Yes, please.
Against this strength, against the total strength of the sitting capacity of trainees, against this 1,292. How many students are here today? I want to show. Against this strength. Next page, page 20 is the first page. This is 2020 to 21. Page 20, NHL 2. This is the cover, first page.
Which page?
Page 20. That's the first page. The relevant page, we have a national relevant page, page 21.
Page.
Page 21. Page 21. May I read it?
Yes,
now?
just wait.
639.
Page 21. Number of trainees undergoing training in ITS during 2020 to 21. Name of threat, ITS Kohima, ITS Dimapur, Mogolchul, Mon, Phat, Tuinsang, Walker, Zunaboto, Kifre. Now, my lord, will see in number 1 for investment of Kohima, carpenter unit. Number 1, investment of Kohima, ITA Kohima, carpenter unit 43. Dimapur, Mogochun, Nil, Mo 10, Phat 6, Tuinsan 24, Woka 17, Zoneboto Nil, Kifre 16. Total for carpenter, total 116 for the whole Nagaland. Next, cutting and sewing. Cutting and sewing. Kohima 1, Kohima 29, cutting 1, sewing 29, Kohima,
Yes.
Dimapur Nil.
Yes, so the total number of trainees is
Total number of trainees 639
Yes.
against the total strength of 1,292.
So what you mean to show is that even for 639, training wings are given the post of deputy director.
Principle where in fact they should have get it also, because practical, look at the trainees. They are originally 1,000 and they are getting principal, vice principal, and the deputy director also in the directorate. Then why you give some post? Government also should have some benefits out of his service. When there is no strength, why? This is the problem Lordship was saying about Route 3. I'm coming to that. why Rule 3 cannot be implemented because of this practical aspect. If the strength is there 10,000, 5,000, then provision is made under Rule 3 read with Schedule 1, Schedule 2A, B, C. So that will be complied by the government. But when there is no strength sitting, when no trainees are there, though the provision is made for future, it is futuristic. If after 50 years, if Nagaland have more than 10,000 trainees, yes, Rule 3 read with schedules, it will come. So therefore, I want to show to this honorable court to clear the doubt. Lordship was asking many questions to my sister. I think, yes, so she has done his part, her part. She has done very well. I'm trying to supplement what she has not covered. Now, therefore, practically today, 639 trainees for the entire Nagaland. Can this honorable court direct the state government that no, they should be given more posts? Well, these are the questions before the Supreme Court. Now, after filing this writ petition, because they have filed this one, subsequently latest the training strength in Nagaland, 2022 to 2023, the latest is 799. 709.
From where are you getting that figure?
This is the additional affidavit filed by the petitioner. This is going against them, the strength. The annexure, this is the page 75 of the additional affidavit filed by the petitioner.
Okay.
Page 75 of the additional affidavit filed by the petitioner.
Okay.
The latest 2023 today, the total training strength is 709. 709.
So there's a slight increase.
Slight increase. So maybe after 50 years, we may have 5,000. Considering the Nagaland population, we must encourage more production. Children. If a family can produce 15 to 20, by 50 we will have grown. At that time we will have 50 strength. But at this rate, the population ratio, let us spread, then Nagaland have more population. Till such time, what is the question of considering their case to give promotion, higher joint director? My God, how this court will
No,
consider?
but if the government wants to create and give them a post, what is your problem?
I have no problem. The problem will be, I have no problem, my lord. The problem will government and in the interest of justice.
You are for the private respondent.
Yes. My lord, I'm rational. My approach is, will the court direct the state government to do something which is injustice? Forget about law. When there is no sitting capacity, when there is no trainees, will the court consider to direct the state government? I have no problem. I have no problem.
We have already expressed our
Yes.
mind that we cannot direct the government to create
My-
posts.
Yes. Lordship, now, as I said, next point. I'm coming one by one. Next point. Paragraph 3, paragraph 5, paragraph 7, 6. Paragraph 3, paragraph 5, paragraph 6 of the writ petition. Repeatedly they said merger, as if we're equal. I'm coming to the question of merger. Because I have verbally made submission. I must satisfy this court with document.
Yes.
Paragraph 3, 5, 6. Keep going merger, we're equal, we're merger. The doctrine of merger. It's a total misrepresentations of facts. It is not a merger. It was transferred, brought under the administrative control of the Director of Employment. There's no ITA there. Lordship, page 22 of my affidavit. Page 22. NHS. So that Lordship would at least believe me on what I say.
No, I'm believing you. We are believing you.
Page 22. Because they keep saying merger.
Page 22
To
also.
my affidavit in opposition. Yes. Page 22. NHL 3.
This type copy.
Yes, type copy. Original is next page. But it is not clear, so we have a next. Original copy also I have a next. But for our convenience.
Yes.
My lord, may I read it?
Yes, please.
Type copy. Government of Nagaland, Labor and Employment Department, Kohima, order, dated 20th May 1986. The government of Nagaland is pleased to transfer the establishment of the Industrial Training Institute, Kohima and Dimapur from the Labor and Employment Department and place it under the administrative control of the Directorate of Employment Exchange. What is the question of merger? Is there any word used merge? Never merge, because they are equal. They are not on equal footing. Transfer and place under the administrative control of the Directorate of Employment Exchange. My lord, the original copy is page 23, but this is not very readable, so we have typed it out. Original copy is page 23, my lord. My lord, then may I proceed with next point?
Just one. And placed it under the administrative control of the Directorate of Employment Exchange. With immediate effect, the Directorate of Employment Exchange is herewith redesignated as the Directorate of Employment and Craftsman Training. So it is only after they were brought under the administrative control of the Directorate of Employment that actually the nomenclature of the department was also changed.
Very much, man. So therefore, my lord, if I read the read petition paragraph, lordship doesn't need to open, I'll just read it. Where they have a merger, misrepresentation of fact, it's directly brought under the administrative control of the employment. My lord, paragraph 3 of the read petition, page 11, middle part. At the time of merger with the employment exchange, there were only two IKs, one at Kohima and another Dimapur. Merger at the time of merger. Total misrepresentation of facts. They should be honest because document is there that we were brought under the direct administrative control of the employment exchange. Big difference between merger and the doctrine of merger, my lord, if you see.
Obviously.
Yes. So therefore, how can they say? Then similar use the word they use at paragraph 5 also. Therefore, upon the merger of the government by letter dated 24/10/86 by order 86 merger. It's a clear case of misprision. Then page 13, paragraph 6. And within a year of the merger of the two, they wanted to project in such a way that we're equal. Merger and amalgamation come only when both are equal. Government knew very well that these two are not equal, therefore they never use the word merger, my lord. I say they were often, they had to be taken care by someone. So therefore they were brought directly under the administrative control of my department.
No, since you have accepted them,
Yes.
why you should keep them in the veranda? You should allow them to access your bedroom also.
My lord,
Kitchen, bedroom, drawing
my
room.
lord, the statutory rules.
Mr.
19,
Mr. Ezo,
my lord.
I hope you are not using the term adoption in a very
My lord.
in a way that suits you.
Anyway, my lord, I'm sorry about it.
When you have adopted them, I think they are now more or less your children, so
Yes.
you should not discriminate.
Correct. No, no discrimination. That's why I'm coming to that. After adoption, they have been given very good privilege under the rules. They have been given the privilege under the rules. They have been given privilege under the rules, and they are enjoying for the last 23 years. Is it correct to challenge these rules after 23 years? After taking the shelter, they are trying to bite me now. Yes. When they were feeling cold, winter, they go, oh, sir, please allow me to stay in your house.
Okay.
They are warm. Now they want to take away all my house. They want to occupy my kitchen. Yes.
Therefore, you have not,
Therefore, I have to,
you have not adopted them.
therefore, I have to at least defend myself. I'm not aggressive. I have to defend myself. And I must assert my right. And I must tell them that the benefit that you have given under this rule is enough for you for the time being.
Okay.
Yes. I'm not against them. Why should I go against them? They are entitled, whatever is entitled for them under this scheme, they are getting. But my problem, that's what I'm saying. My problem start only when they say we're equal. Only when they say we're merged. Only when they say we have equal mission. Only when I have problem, only when they say entrepreneur is same. I have problem only when they say there is two separation. Where is it? Sure. Problem lies there. Therefore, I say, my Lord, I am defensive, not aggressive. And I am not aggressive. I should not show my attitude also. But one should know that you are under my shelter. One should know that you are under my directorate. And one should remember that they are beautiful teaching institute. That also to give swing trainings for 3 months, 6 months, workshop walas, stitching, cutting. So your role is limited, my dear friends. That's what I'm trying to say to them. Your role is limited. Whereas for us, we have to, as a parent, we have to look after the structure of the family. Everyone is equal. I should give them protection, which is permissible under the rule. This is what I'm trying to say. I'm not against anybody. Right.
You are even trying to obstruct what the government wants to give them.
No.
As per the rules, the government wants to give them the post up to the director. But you are vehemently objecting to that.
My lord, I'll serve lordship. Lordship, government is a welfare state. They have made a problem rule 3 down the schedule. Tomorrow, government should be futuristic. Tomorrow, after 20 years, after 50 years, if number of sitting cabinet increases, if 20 increases, sure, there should be a room for anybody coming after some year. But today, lordship was total stand 709, which is not qualified for even principal. And that also institute means Mojo Institute, Woka Institute, Zonegoto. It should be like that, not the whole state. Every district has institute, training institute. There, I feel 20, 60, 5, 15, each institute. Is it eligible to have a principal there? That's what I'm saying. I'm just putting a question. Why Nagas are not willing to come and take training from this institute? What kind of quality they are producing? If there's quality, obviously I'll send my children. Lordship also will send your children. Why that trainings are not coming? And why trainings are not there? Is it necessary for the government to appoint more teachers than students? The number of teachers will become more than students. If that is so, will it not amount to?
You are indirectly kicking the government.
So therefore,
while you are actually supporting the rules framed by the government, you are also indirectly kicking the government.
My lord, my point now, when they are asking for equality, when they are asking for promotion at par with me, that is my point. How can whatever government has given you, that's enough for you for the time being. Because every district institute that you have to have 20, 10, 30, demanding for director post, which is not for teaching. So therefore, something, somewhere, their demand is not justified. Now,
This number prescribed under the guidelines,
yes,
these are for a particular institute,
yeah,
not for a district. Not for a district.
in a district there is an institute.
There's one, so what I mean to say is that this numbers,
Yes,
which is prescribed by the guidelines, these are only for a particular, for a single institute.
yes, very much, very much. For institutes, it makes the UP Delhi Bihar. How hundreds of institutes are because they're imparting like that skill employment. All this, but Nagaland, look at the fact of Nagaland. Trainees are not coming forward. The guidance lordship has rightly pointed out. That guidance talk about for every institute, not the hall. Because this guideline comes under concurrent list. Concurrent list, we are talking about forest dispute now in Nagaland, not only in all over. Forest also comes under concurrent list. So therefore, we cannot totally ignore the guideline given by the central government, while the subject matter is part of the concurrent, falls under concurrent list. Right. Then, Lordship, I have undertaken 30 minutes now. My Lord, I'll just show you the scenery.
We are imposing cost. As per the assurance given to the court, we have to impose cost.
My Lord.
Or else it will be contempt of the court.
But my Lord, Lordship should be fair now because
Please continue.
my friend has taken 2 days.
Please continue. Please continue.
My Lord, now the oral submission that I am advancing about seniority. One is seniority. Seniority. Whether there is any common seniority as claimed by them. Whether there is any common seniority as claimed by the petitioner. If it is same cadre, there shall be only one common seniority. Lordship knows very well about which you are well experienced, vast experience. My Lord, page 35 of my affidavit position. Seniority, latest seniority we have annexed.
Page
35, NHL 9, in my affidavit position. Page 35 of my affidavit position, NHL 9. This is the forwarding letter. Next is the signature post. Well, may I read it?
Yes, please.
Yes. This is 2021 seniority list. My Lord, issued by the directorate. I don't need to read the first covering letter.
Yes.
Yes. Now, the heading itself says, forwarding of the latest updated seniority list of gazetted officials and Directorate of Ministerial Staff of the Employment, Skill, and so and so, so and so. Now, next page.
This is as on 31/7/2021.
Yes, ma'am.
Just read it as on. Yes, please.
Page 36 is the seniority list of the employment wing. Page 36 is the seniority list of the employment wing.
Yes, please.
Then next page 37 is the seniority list of the training wing. Therefore, even seniority is also maintained separately. There's no question, there's no confusion that who will be senior, who will be junior between the two. I'm very sorry, I apologize. 2004, we couldn't annex that my colleagues have overlooked. 2004 also we have seniority list where starting from 2004 till today. Nowhere it is maintained common seniorities. From 2014 today, they are not agreed. From 2014 today,
We have that 2004.
yes.
Let's just have a look.
My colleague, they have overlooked. I'm so sorry. I apologize for that. Sure.
Mr. Tom Polk, this was your case. Why have you not annexed all this?
Your Lordship, it is not my case that there are joint seniority lists. There are separate seniority lists in my petition also. He is only reiterating what I have stated in my petition, Your Lordship.
Gazetted officers.
So this 2004 separate seniority list for the employment week.
Final seniority list in respect of the.
There is no dispute regarding this, Your Lordship.
First is employment win. Second, page 2 is training win. Training win only for senior principal, principal to vice principal.
So which is for the employment wing?
First page, man.
Oh, this is for the employment wing.
Employment win. The next page is training win. And the strength of the training motion mechanism
Training wing. Yes.
only for so this is 2004. Since 2004 till today, there is no common seniority list. This is what I'm trying to make my submission, my lord. So therefore, what is the question of equality? If lordship is satisfied on that point, I'll refer to this rule. And then after that, I have to read out my.
What is that?
My lord, after break, then my lord.
Yes, we will resume at 2.
Yes, I do.
Okay.
Much obliged.
Yes,
May I please
Mr.
talk?
Ashipri.
My lord, since I'm talking about the entry point, different entry point, my lord, I'm taking
You were on the seniority list, na?
the entry point. I have finished seniority.
You
I
have
have
finished.
Now coming to entry point as per the rules now. Entry point, different entry points as per the rules. I'm coming to the rules.
Rules, this rules, is it a part of the petition?
Yes, part of the petition.
Uh,
But I'm providing separate rules so that,
why confuse us again?
okay.
Your entry point itself is wrong. Just now, brother has pointed out this. Just see your,
Yes.
just see your, this thing, Article 308.
My lord,
Article 308, from what the government is going to.
I already noticed. The article itself is wrong. We already noticed. This is,
That way, she was correct. There's a typographical mistake.
yes, my lord. Instead of 309,
I didn't notice.
we have noticed already.
Okay, that is in page 64 of the petition,
My lord,
correct?
yes.
Page 64 of the petition.
66, I think.
64, then
I'm coming schedule 1A, my lord.
schedule 1,
64, yes.
Yes, schedule 1A.
schedule 1, this. Schedule 1A.
Yes. The entry point. Schedule 1A, the entry point for the class 2 gazette. The entry point for the class 2 gazette.
This is rules 1998, na?
My lord, 1990. 1998, yes. My lord. The entry point for the employment official,
And 3 for employment officer.
class 2 gazette, entry point.
Serial 7.
7.
Ah,
So entry point for the employment wing is under schedule 1A, serial number 7, where it shows that the entry point is employment official. Because I have made my oral submission that entry point is different.
why not a technical assistant?
But
Why?
that is class 3, non-gazette, class 3. Class 3. That is class 3, man. Non-gazette. Class 2 is serial number 7. Class 2 gazette, employment official.
Ah,
That is schedule 1A.
employment officer.
Yes. Now, in the case
What is this G? Gazette?
gazette, my
Okay, non-gazette then G.
lord. Now, my lord, just schedule 1B, the entry point is class 2, vice principal, class 2 gazette. That is serial number 1.
This with independence.
Vice principal. The entry point for the training wing is vice principal.
Entry point. And
Plus
schedule,
gazette.
this schedule
Schedule 1B.
1B. The vice principal is the
Vice,
entry point.
that is the entry point for class 2 gazette. So, my lord, therefore, my submission that the entry point is different is correct as per the rules. For the employment wing, employment official, class 2 entry point. Then for the training cadres, training wing, vice principal is the entry point, class 2 gets it, madam. So what my submission is as per the rules, madam.
Yes.
Going back to schedule 1A, non-gazette, my lord. Serial number 8, technical assistant. In the case of employment, class 3 non-gazetted. Class 3 non-gazetted.
Yes.
Then in the case of training wing, schedule 1B, schedule 1B for class 3 non-gazetted. My lord, back to last page. Last page, my lord. Trade instructor. Last page. Under schedule 2B, last page. Under schedule 2B, last page.
Yes, wait.
This is trade instructor. The entry point for class 3 non-gazette for the training wings. Trade instructor. Trade instructor. Entry point. Then, my lord,
So what you mean to say is that in
entry point is different.
Schedule 1A,
Yes.
the entry point for class 3 non-gazetted is technical assistant,
Yes, ma'am.
and as per Schedule 1B,
Training
the entry point for non-gazetted class 3 is trade instructor.
trade instructor. So entry point is different, totally different. Now, after that, now I'll be showing lordship regarding qualification. Qualification.
Yes, we.
I say qualification is so different.
Yes, we. Yes, please.
My lord, then regarding qualification, schedule 2A, this is employment wing. Schedule
Schedule
2A. Schedule 2A employment wing.
Schedule 2A.
Yeah.
Yes, wait.
This is employment
Schedule 2A.
employment wing.
Yes, wait.
Serial
Yes.
number 7, the qualification on the right side. Employment officer, next column 5, qualification.
Yes, wait.
Degree in arts. Qualification. Degree in arts, science, commerce, or any degree certificate from any stream. Start degree in arts, science, commerce, anything. Starting with arts, degree in arts, science, commerce, agriculture, and engineering.
Ah,
That is the qualification for the employment official.
and that also applies with serial 8.
Yes. Serial 7.
Serial 8 also same
Serial 7,
qualification.
correct, ma'am. Madam, yes, ma'am, you are.
Yes, please.
Then, my lord, regarding the qualification for the training wing, schedule next page, madam, schedule 2B. This is training wing, qualification for training wing.
Yes.
Serial number 5, entry point for class 2 cadet, vice principal. On the right side, qualification. B.Ed mechanical, electrical, civil, electronic, all this science technical qualification. only technical qualifications required for the training week, my lord. Then next, my lord, next reverse side, last trade instructor for grade 3 entry point qualification. Qualification for grade 3 instructor. Last page, my lord. Column 5. Column 5, the qualification for trade instructor is matriculated and its equivalent. Metric is the minimum they can have above qualification, not doubt. But metric is the minimum qualification. Metric and above. They can have higher qualification, no, but the minimum qualification is metric.
What is metric?
Plus 10. Plus 10 pass.
Here it says, METRIC. METRIC. Is to do something with measurement. Huh? Madam, I think.
Lordship is very meticulous.
No, but I think this was actually drafted by some very, very technical person.
But, so, matriculate is the minimum for the trade instructor. Whereas for me,
Metric is 100% will be filler with maths and science. But then what are all this degree in science, arts,
but minimum is matriculation.
and all these are applicable. Degree in
You
science.
can have anything, but minimum should be plus 10.
Yes, please.
So now, my lord, therefore, Lordship has also given thought whether Rule 3 should be read with all these schedules. I say yes. Because Rule 3, this is the structure, the provision made for the future. Rule 3 has to be read with the schedules only when sufficient sitting capacity of the trainees are made available, only then as per Rule 3. There shall be sanctioned post, Lordship, post-graduation has to be done. Only post-graduation will be done only when there is a necessity. When there is necessity, government should create posts as per Rule 3. But for the time being, since necessity doesn't arise, therefore post-graduation has not been created. Now, like I have made my mention in the morning, like as per CRP section 25, which provide that there shall be Directorate of Public Prosecution. But nowhere, except in big states, in entire India, few smaller states, they never have Directorate of Prosecution because the requirement, necessity is not there. So the post-creation is not there even for the prosecution. Similarly here also, my lord. Rule 3 says yes, necessity arises, post-creation has to be done. After post-creation, training will not, if you have the required numbers of trainees, why not? Equal treatment should be done. But today, since Lordship have seen that number of trainees are only latest 2023 709, which is not necessary for even vice principal. So therefore, government felt that necessity doesn't arise to create the post of joint director, additional director for them. This is my humble submission, my lord. Now, my lord, as far as rule concerned, that's what I wanted to close. Now, my lord, Lordship has instructed all of us to make a short written submission. So I have prepared, I'll just read out and then I'll not take much of Lordship.
Where is the citation?
I have written here.
In your written submission?
I'll read it out.
Okay.
So that penalty on taking more time should be less. My lord. May I read it, my lord?
Yes, with the. You have a respondent number 5 to?
5 to 60, my lord. I have written there.
Yes.
May I read you, my lord?
Yes.
WPC number 261 of 2021. Engineer Gauhati and 6 others versus State of Nagaland and others. Written submission for the private respondents 5 to 16. One.
Take them.
At the outset, the private respondent hearing referred
You hope you will not take another 1 hour
my lord
by reading this.
I'll just read out. I'll not repeat it so much. Yes, thank you so much for giving patient hearing. At the outset, the private respondent hearing after referred as PR would like to raise a preliminary objection regarding maintenance of the repetition as follows. 1. Yes, the petitioner having entered in the services of the craftsman and training wing of the directorate comprising of 2 wings, namely employment wing and craftsman training wing, as per the provisions of the relevant rules, they cannot now resile back from that position being barred by the principal waiver, estoppel, and acquiescence. B. The petitioner have misrepresented the facts in stating that the 2 wings have been merged. As clarified in the counter affidavit, there is no merger of the 2 wings. In fact, the industrial training wing was placed under the administrative control of the Directorate of Employment Exchange by an order dated 25/1986, annexure 3 to the affidavit in opposition filed by the private respondent and respondent is a copy of the said order, and thus, to that extent, there have been misrepresentation of facts. The repetition is liable to be dismissed on that ground alone. C. The instant writ petition was initially filed by 7 petitioners, including Engineer Gauhati, who was petition number 1, and also sworn the affidavit verifying the facts of the case. During the pendency of the writ petition, petition number 1, Engineer Gauhati filed IAC 188 of 2022 to strike off his name from the case. Accordingly, WPC number 261 of 21 was listed along with IA 188 of 22 on 9/11/2022. On the prayer of the applicant through Land Council Mr. Tompo Pongnar, this honorable court was pleased to strike off the name of Engineer Gauhati from the list of the petitioner in WPC 261 of 21. Now, since Engineer Gauhati had already withdrawn from the case, the affidavit sworn by him accompanying the writ petition is also deemed to be withdrawn. Hence, the writ petition is not accompanied by a sworn affidavit as required under the Gauhati High Court rules. On this count alone, the present writ petition is liable to be dismissed. My Lord, rule, I have the High Court rule, but Lordship knows about that. Chapter 5. If the writ petition is not accompanied by a sworn affidavit, the word shall.
We're considering the constitutionality of the rules. Why go for all this technical?
But then it is shall mandatory for the petitioner to file the writ petition accompanied by a sworn affidavit. Here it is not. I leave it to Lordship. That is what High Court rule says, shall.
Maybe that is actually mandatory during the initial time of filing the petition. This is a continuation.
The case is pending. The case is pending. And this is the writ petition. Without accompanying by a sworn affidavit. Without accompanying by a sworn affidavit. As per High Court rule, chapter 5. Well, 2. That the government write notification number so and so that the 22/10/1998 amended the Nagaland Employment Services Rules of 1984 and have brought out a new rule called the Nagaland Employment and Craftsman Training Service and Nagaland Subordinate Employment and Craftsman Training Service Rule 1998, quote, unquote, to regulate the recruitment and conditions of the service of persons appointed to the Nagaland Employment and Craftsman Training Services. The intention of the government was to introduce the aforesaid rules, which is based on 2 principles. Firstly, the employment wing of the department will be in charge of the administrative functions of the entire department. The craftsman training wing would discharge its duties and responsibilities towards the institute to give vocational training to the trainees for different trades under the Directorate of Employment, Skill Development and Entrepreneurship, Nagaland. Secondly, to create two separate entities of both the wings as per the requirement under the law. Additionally, for the two different wings, two different seniority lists are being maintained. Both employment wing and training wing falls under the concurrent subject. Therefore, all the states and union territories make rules in consonance with the guidelines given by the central government for staffing pattern. Thus, Rule 3, which makes provision for method of recruitment and promotion of training wing, can only be done by following the guidelines of the norms and of for staffing pattern at the Directorate of the States and Union Territories for implementation of craftsman training scheme. Rule 3 cannot be read in isolation, but read together with Rule 4 and 5, which shall clearly indicate the intention of the lawmaker on the question of recruitment and promotion. As for the craftsman training norms laid down by the central government, the post can be created as follows. Name of the post, seating capacity. Additional Director of Training, one post is for 5,000 to 10,000 seats. Joint Director of Training, 3,000 to 7,000. Deputy Director of Training, 2,000 to 4,000 seats. In the state of Nagaland, the total available seat for the trainees under ITI is 1,292 only. However, during 2020 to 2021, there were only 639 trainees against 1,292 available seats. Till today, the number of trainees never reached 1,292 seats. Therefore, though Rule 3 makes provision for future promotion for the training wing like employment wing, the state government has not created the post of joint director and above for training wing due to non-fulfillment of the norms for staffing pattern laid down by the central government. The existing staffing pattern of ITIs in various states and union territories clearly show that no state union territories has created posts beyond the deputy director or principal. The Rule 3 of the Nagaland Subordinate Employment and Craftsman Training Service Rules 1998, which makes provision for constitution of service, clearly provides that the service shall consist of two separate wings with different nomenclatures. Further, the Rule 3 also provides that both wings will be headed by the director and both wings will be under his command. It is well settled law that it is open to the government to constitute different cadres or wings in any particular service or department as it may choose according to its administrative convenience and expediencies. The office of the director under Rule 3 is the apex office to control and observe the functioning of the subordinate offices and the wings, within bracket, craftsman wing and employment wing, that are under his control, and to maintain the implementation of the government employment and craftsman training program. The necessity to maintain separate wings for employment and craftsman training under the directorate is primarily an executive duty, and therefore the government is in the best position to decide whether it requires separate wings under the directorate or not. Each wing has its separate administrative service or is a part of a service may sanction for different administrative expediency. Therefore, each wing is a separate unit and the posts allocated to the wings are different from each other. Though the office of the directorate controls both the wings, that does not signify that the employment wing and craftsman training wing are treated under the rule as one unit. It is also pertinent to mention herein that after the appointment are made and the candidate join in the post, consideration for promotion is guided by the rules that occupy the field, and therefore the petitioner, after joining the service and working in the craftsman training wing, cannot now say that there is disparity in service, that too after getting the benefit of the wings. In the instant case, the petitioners have miserably failed to bring out any unconstitutionality to Rule 3 of the rules. The expression used by the petitioners within court, that Rule 3, which makes provision for constitutional service, clearly provides that the service shall consist of two equal wings, open invert, employment wing and craftsman wing, is again a misrepresentation of fact. As will be evident from Rule 3, there will be two separate wings with different nomenclature. In this connection, Rule 4 of the rules may also be referred to, which clearly indicate separate entity of the two wings. Rule 5A and B also makes the position clear. While Schedule 2A, Rule 5 deals with the employment wing. Schedule 2B deals with training wing. While under Schedule 2A of the employment wing, the entry-level post is employment officer, Class 2 Gazette, with a qualification of degree in arts, science, commerce, etc. from any recognized university. Under Schedule 2B of the training wing, the entry post is that of a vice principal, Class 2 Gazette, with BA mechanical engineer or technical qualification or its equivalent from any recognized university. Under Schedule 2A, employment wing, the entry-level post for Class 3 non-gazette is that of technical assistant with a qualification of degree in arts, science, commerce, etc. Whereas under Schedule 2B training wing, the entry-level post for Class 3 non-gazette is that of a track instructor with a qualification of matriculation or its equivalent and above. This will clearly establish that no parity can be brought in, as has been claimed by the petitioners. By no stretch of imagination, it is a case of equals being treated unequally. Rather, it is a case of maintaining standard norm for two separate wings. Furthermore, under Rule 5, Schedule 2A belongs to the employment wing and Schedule 2B belongs to craftsman wing. Therefore, the aforesaid schedule will apply for the respective wing. The rule itself made a distinction between the person appointed in employment and training wing by creating separate cadres and separate entry-level posts for both the wings. Therefore, the petitioner cannot be considered to be equally placed for treating them at par with the employment wing employees. There is a reasonable nexus to differentiate the two wings. Therefore, the classification cannot be said to be arbitrary and violating of Articles 14 and 16 of the Constitution of India. In a system governed by rule of law, discretion must be with clearly defined limits. The aforesaid Rule 5 of 1998 provides the guidance for exercise of the discretion in making appointment in both the wings by maintaining separate selection lists, seniority list, gradation list for both the wings, which are being prepared and maintained for long before. A rule can only be said arbitrary if the discretion is exercised without any principle or without any law. A discretion which is guided by law or governed by a non-principle of rules cannot be said to be arbitrary and violative of Articles 14 and 16 of the Constitution of India. In the instant case, the discretion stated in Rule 5 is a sound discretion guided by law and principle of rule of law, and therefore it is legally valid. Paragraph 3. The petitioner number 1 to 7 belong to craftsman training wing, and private respondent number 5 to 16 belong to employment wing. While the employment wing is in charge of the administration of directorate, the craftsman training wing is in charge of separate duties and responsibility of the institution to teach the vocational trainees for different trades like knitting, cutting, sewing, plumber, welder, carpenter, mechanic, diesel, electrician, etc. Thus, there is no question of bringing in any parity as is sought to be done by the petitioners in the instant case. It is a cardinal principle of Constitution that the statute or rule of the regulation must be held to be constitutionally valid until and unless it establishes that they violate any specific provisions of the Constitution of India. Further, it is the duty of the court to harmoniously construe different provisions of any act or rule or regulation, if possible, and to sustain the same rather than strike down the provisions outright. The Rule 5 of Nagaland Employment and Craftsman Training Service and Nagaland Subordinate Employment and Craftsman Training Rule 1998 provides for two separate wings. Therefore, the question of equal wings does not arise. The benefits conferred in the Rule 5 are given in both the wings. In view of the above, when the Rule 5 separates both the wings with regard to entry to the post, qualification, pay scale, duties, and responsibility, the question of parity between both the wings does not arise. Under the facts and circumstances as stated above, it can be seen that the Rule 1998 rules is at par with the different act and rules in other states, and thus the question of illegality and violations of the Constitution of India does not arise. 4. The concept of equality under Article 14 of the Constitution of India can have no existence except with reference to the matters which are common as between individuals, between common equality is predicated. Equality of opportunity in matters of employment can only be predicated between persons who are either seeking the same employment or have obtained the same employment. It is therefore clear that the matters of promotions and matters relating to employment are within the meaning of Article 16(1). Such equality of opportunity in matter of promotion must mean equality between members of the same class of employees and not equality between members of separate independent wings. In the instant case, the employees of employment wing and employees of craftsman training wing are recruited separately, trained separately, and have separate avenues of promotion, and as such, the finding is irresistible that they form two different distinct and separate classes as between whom scope of predicating equality or inequality of promotion does not arise. What constitutes inequality under Article 14 depends upon the facts of each and every case. The context provided under Article 14 of the Constitution of India is that in every statute or rules where intelligible differential exists, there is grouping of the employees based on that intelligible differential and leaving out those employees who do not share the intelligible differential. Further, the intelligible differential must also have rational nexus that is sought to be achieved, and the requirements of intelligible differential should be made within the law or rules, and it should not interdict within a class of employees. In the instant case, the existence of intelligible differential is clearly there between the employees of employment wing and the craftsman wing. The Rule 5 of the aforementioned rules stipulate the intelligible differential between the wings to have or by having different schedule for different wings. The employment wing is in charge of the administrative function, while the other wing, that is craftsman training wing, is in charge of training and craftsmanship involving completely separate duties and responsibilities. 5. In the instant case, the government of Nagaland, by following the employment and craftsman training service norms, have made two separate wings under the one directorate. The duties and functions of both the wings differ from each other. The nature of service, payroll, seniority, graduation leave are also different. Therefore, the Nagaland Employment and Craftsman Training Service Rule 1998 should not be interfered by the court, as the legislature has all the rights to create difference between two classes of employees of different nature. 6. The two services of the wings started as independent services. The qualification prescribed for entry into each wing are different, very different. The method of recruitment and the machinery for the same were also different. The general qualification possessed by the members of each class is also different. It started as two distinct classes, and there are two distinct services. And there is no intersectionality between the two services or wings, nor any comparison can be made between the two services or wings in the matter of promotion for making or founding an argument based upon the principle of Article 14 and 16(1) of the Constitution of India. Both the wings started dissimilarly and they continue dissimilarly, and any dissimilarity would not be a denial of equal opportunity. Moreover, the policy decisions of the government of Nagaland to create and run two distinct and separate wings under one directorate cannot be called in question, the same being founded on reasonable criteria and service conditions. The petitioners have miserably failed to bring the in the principles relating to holding a service rule unconstitutional, as there is no violation of any of the constitutional provisions. 7. It may not be necessary to refer various decisions of the High Apex Court on the scope of Article 14, particularly on the question of discrimination. It is well settled law that equality before the law means that among equals, the law should be equal and should be equally administered, and that like should be treated alike. However, the principle does not take away from the state the power of classifying persons for legitimate purposes. One of these are the judgments. In Amir Unisa Begum versus so and so, report in AR 1953, Supreme Court 91, it was held thus. Paragraph 11, relevant paragraph, para 11. A legislature which has to deal with diverse problems arising out of an infinite variety of human relations must, of necessity, have the power of making special laws to attain particular objects, and for that purpose, it must have large powers of selection or classification of person and thing upon which such law are to operate. Unquote. In state of West Bengal versus so and so, reporting AR 1952, Supreme Court, page 75, it was held thus. Paragraph 54. The classification must not be arbitrary, but must be rational. That is to say, it must not only be based on some more qualities or characteristics, which are to be found in all the persons grouped together, and not in all others who are left out, but those qualities of characteristics must have a reasonable relation to the object of the legislation. In order to pass the test, two conditions must be fulfilled, namely 1, that the classification must be founded on an intelligible differentia, which distinguishes those who are grouped together from others, and 2, that the differentia must have a rational relation to the object sought to be achieved by the act. The differentia, which is based on classification and object of the act or rule, are distinct things, and what is necessary is that there must be a nexus between them. Unquote. In E.P. Royappa versus State of Tamil Nadu, 1974, 2 SCC, and Manika Gandhi, so and so, the Supreme Court has held that Article 14 strikes at the arbitrariness in state action and ensures fairness and quality of treatment. In D.S. Narakara and others versus Union of India, 1983, 1 SCC 305, the above three judgments are referred and the ratio laid down is as under. Paragraph 15. Thus, the fundamental principle is that Article 14 forbids class legislation but permits reasonable classification for the purpose of legislation, which classification must satisfy the twin test of classification being founded on the intelligible differentia, which distinguishes person or thing that are grouped together from those that are left out of the group, and the differentia must have a rational nexus to the object sought to be achieved by the statute in question. Unquote. In All India Station Masters and so, reported in year 1960, Supreme Court, Supreme Court held as follows. Para 8. It is clear that as between the members of the same class, the question whether conditions of service are the same or not may well arise. If they are not, the question of denial of equal opportunity will require serious consideration in such cases. Thus, the concept of equal opportunity in matters of employment apply, however, to variations in provision as between members of different classes of employees under the state. In our opinion, the answer must be in the negative. The concept of equality can have no existence except with reference to matters which are common as between individuals, between whom equality is predicated. Equality of opportunity in matters of employment can be predicated only as between persons who are either seeking the same employment or have obtained the same employment. Proceeding further, the court held thus. there is, in our opinion, no escape from the conclusion that equality of opportunity in matters of promotion must mean equality as between members of the same class of employees and not equality between members of separate independent classes, unquote. The same principle was later confirmed in the case of Kishori so-and-so, reported in AR 1962, so-and-so. The above ratio has been followed in so-and-so case versus reported in 1968, SC 81, wherein this court observed as under paragraph 6. Quote, it is entirely wrong to think that everyone appointed to the same post is entitled to claim that he must be paid identical emoluments as any other person appointed to the same post, disregarding the method of recruitment or the source from which the official is drawn for appointment to that post. No such equality is required under Article 14 or 16 of the Constitution of India, unquote. Instead of Punjab versus Joginder, so-and-so, reported in 1963, SC, in paragraph 21, the question has been considered, and it is held that the question of denial of equal opportunity could arise only as between members of the same class, and that it was open to the government to constitute two distinct service sector employees doing the same work but subject to different conditions of service. The court also concluded that the assumption that equal work must receive equal pay was not correct, and that it was also not correct to say that if there was equality in pay and work, there must be equality in condition of service. Paragraph 8. Article 16(1) of the Constitution provides, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the states. The Supreme Court in dealing with the extent of protection of Article 16(1) observed in General Manager Southern Railway versus so-and-so, reported in 1962 SC in paragraph 14. That quote, it would be clear that matters relating to employment cannot be confined only to the initial matters prior to the act of employment. The narrow construction would confine the application of Article 16(1) to the initial employment and nothing else. But that clearly is only one of the matters relating to employment. The other matter relating to employment would inevitably be the provision as to the salary and periodical increments therein, term as to leave, as to gratuity, as to pension, and as to age of superannuation. These are all matters relating to employment, and they are must be deemed to be included in the expression matters relating to employment in Article 16(1). What Article 16(1) guarantees is equality of opportunity to all citizens in respect of all the matters relating to employment as stated above. Paragraph 16. The three provisions of Article 16, 14, 15 form part of the same constitutional code of guarantees and supplement each other. If that be so, there would be no difficulty in holding that the matters relating to employment must include all matters in relation to employment, both prior and subsequent to the employment, which is incidental to the employment and form part of the term and condition of such employment, unquote. Dealing with Article 16(1) of the Supreme Court has thus observed, quote, Article 16(2) prohibits discrimination and thus assures the effective enforcement of the fundamental right of equality of opportunity guaranteed under Article 16. The words in respect of any employment used in Article 16 must therefore include all matters relating to employment as specified in Article 16(1), paragraph 17. In Madras Bar Association versus Union of India, reported in 2021 in paragraph 69 and 69 and 89 reads as follows. The Supreme Court has held that the court cannot direct the legislature to enact a particular law when an executive authority exercises a legislative power by way of subordinate legislation pursuant to the delegated authority of the legislature. Such executive authority cannot be asked to enact the law which it has been empowered to do under the delegated legislative authority. It is equally true that judiciary in exercise of power of judicial review cannot direct legislature to frame any law in a particular manner. The petitioner number 1 to 7 belong to craftsman training, and respondent number 5 to 16 belong to employment wing. Thus, no parity can be pleaded between them. Rather, further, while employment wing is in charge of the administration vested with administrative function, the other wing, that is craftsman training wing, is in charge of the training and craftsman involving completely separate duties and responsibilities. It is not a case of composite cadre with equation of post, etc., but a case of two separate wings with different duties and responsibilities. Mere equation of nomenclature of any post is not the deciding factor for equation of post. In the instant case, there are two distinct and separate wings in the directorate, which by no stretch of imagination can be equated. Therefore, the discrimination under 16 of Constitution of India does not arise. 9. When employees are drawn from different sources and is being absorbed and reintegrated in a new department, it is primarily for the government or the executive authority concerned to decide as a matter of policy how the equation of posts should be effected. It is well settled law that the court cannot interfere with such a decision unless it is shown to be arbitrary, unreasonable, unfair. If no manifest unreasonableness is met out, the court will not sit in an appeal and examine the propriety or wisdom of the principle of equation of posts adopted by the government. In the instant case, the government decided to bring the employees of the craftsman training wing under the administrative control of Director of Employment, Skill Development and Entrepreneurship, Nagaland. And thereafter, by amending the Nagaland Employment Rules 1984, the government of Nagaland regulated the service of employees appointed under Nagaland Employment and Craftsman Training Service by bringing in 1998 amendment. The Rule 5 of the amendment clearly distinguishes the two wings of the directorate. The discretion or the distinction in the Rule 5 is discussed in the above paragraph is reasonable, fair, and not arbitrary. Therefore, the parity of services the petitioners have sought to bring in the instant case is allowed, if allowed, will lead to disparity, leading to violations of exceptions provided to equality clause in the Constitution of India. My Lord, this is my humble submission. With this, my Lord, I sum up. And in my humble, respectful submission, considering all this, the writ petition filed by the petitioner in this present case is liable to be dismissed because they could not establish any case to challenge the rules. Much obliged.
Mr. Tongpok?
Yes.
We will not be giving you more than
I will not take more than, I will
10,
just,
15 minutes.
yes, Your Worship. My written submission, Your Worship.
Yes, just,
I have laid down in brief the facts, and I have also indicated the paragraphs in my writ petition that are, and the citations is at the end, Your Worship. Now, Your Worship, with regard to the statement and submission of the learned additional agent, she has gone out of the bounds of her affidavit, Your Lordship. Your Lordships know very well that parties are bound by the affidavits they have filed. So the submission of the learned AG is outside what she has stated in the affidavit. Your Lordship, I will take your Lordship to her case in the affidavit. Paragraph 7 of the affidavit, Your Lordship.
Yes, wait.
This encapsulates the stand of the state respondents. Paragraph 7, Your Lordship. May I read, Your Lordship?
Affidavit.
Affidavit in opposition filed on behalf of respondents number 1, 2, 3, and 4.
1, 2, 3, and 4.
Yes. Paragraph 7 and 8, but 7, it encapsulates the stand of the state respondents. 8 is,
This is 22nd for 2022.
yes, 22 for 2022. 7.
Yes, wait.
If I may read, Your Lordship.
Yes, wait. Which para?
Para 7, Your Lordship, page 5. If I may read, Your Lordship.
Yes.
That as regard to statement made in paragraph 7 of the petition, nowhere in the service rules 1998 it is stated that the two wings, that is employment wing and the training wing, are two co-equal. Till date, there is no command seniority list maintained in the department. Whereas of the service rules 1998 provides for constitution of service. Schedule 2A regulates the promotions of the employment wing, and Schedule 2B regulates the promotion of the craftsman training wing. In fact, considering that the two wings, the employment wing and the training wings, are distinct from each other, the Department of Personnel and Administrative Reform has also suggested to examine the feasibility of bifurcating the two wings as reflected in the letter dated so-and-so of the Additional Secretary to the Government of Nagaland Labor and Employment Skill Development and Entrepreneurship Department and addressed to the Director Employment, Skill Development and Entrepreneurship. It is stated that Rule 3 and 5 of the Service Rules 1998 read with Schedule 1A and 1P, and Schedule 2A and 2B provides for the constitution of service, strength of service, and method of recruitment for both the two wings. It cannot be said that equals are being treated unequally, since both the wings, as mentioned above, have separate promotional avenues as well as separate seniority lists. The deponent crafts for the leave of this Honorable Court to refer to and rely upon the Service Rules 1998 at the time of hearing of this petition. This is the only stand that has been taken by the state respondents. There is no mention here about the national manuals, Your Lordship. Now, Your Lordship, I will take Your Lordship to the national manual. Preface to the national manual, Your Lordship. I have given clear answers to this in my which is in my affidavit in reply to the affidavit filed by the private respondents 5 to 16.
The affidavit dated?
Affidavit dated 2/5/2022. They have the state respondents as well as the private respondents have harped on this Industrial Training Institute manual, Your Lordship. Page 15, Annexure I.
No, Mr. Tongpo.
No, Your Lordship, I'll take Your Lordship only do that.
We need not go to all this.
No, I'll take Your Lordship.
We have seen what is the rules. And you are governed by the rules.
Yes, but since they are standing on this, I will take your lordship only to one small paragraph.
We may not consider all this.
Your lordship.
We will consider your case only as per the rules.
Your lordship, then it is very clear.
We will consider your case only as per the rules.
Yes, your lordship.
Yes, because that is what is relevant for us.
So, your lordship, in that case, I need not go any further.
Yes.
But the state respondents, their statements are not tenable because there is no mention in the rules regarding the national manual. The national manual clearly says that it is not a legal document. In the preface itself, it is very clear. It is not a legal document. It is for mere guidance or proper implementation. So, the service rules alone speaks, and the service rules has to be considered on its own merit. Your lordship knows
No,
more than I do. That
You have both the
Yes.
parties, they have submitted so many guidelines, this, that.
Yes, your
But
lordship.
ultimately, it is the rules. It is the
boils down
rules
to the rules, your lordship.
on which we will have to decide.
I have, in my detailed submission, I have made all the citations necessary. If I had all in during my submission, because of the time constraint, I referred to only one case. But I have also cited other cases in the paragraphs, your lordship.
Where is your written
Page
argument?
5.
Just wait, where is your written argument? Written argument?
So those are all. So, if your lordship is pleased that I need not go into read all the citations, your lordship, those are my citations, and the paragraphs I have cited, your lordship.
But Mr. Tongpok,
Yes, your lordship.
as per the rules, the entry point in two different wings, those are separate.
They are
They-
separate, your lordship.
The posts are separate.
Yes, your lordship.
The qualification required is separate.
Your lordship, I am aggrieved from the post, from the grade of deputy director upwards, your lordship. From the grade of deputy director and upwards.
No, but
Because both wings have deputy directors, your lordship. Both wings have deputy directors assigned to them. And the nature of their work is same. They are deputy directors, they are administrative in nature, purely, your lordship. So here, what I am saying is that since Rule 3
but,
clearly lays down,
what-
there should be equality for both.
one can come up to the post of deputy director only from the post below. And in the post below, the criteria required for appointment, for promotion, everything is different.
They are different, your
So
lordship.
how can you say that you are aggrieved only from the post of deputy director and upwards?
Your lordship, your lordship will see the Rule 3 and then the schedules. How the schedules contradict the Rule 3. Rule 3 clearly shows that these two wings are equal, your lordship. And there are posts, equal posts assigned to both. That is my only case. If your lordship finds that this Rule 3 can be overridden by
No, but they are,
the schedules without the state respondents giving any justification. There is no justification.
no,
Yes.
they are different cadre. Different cadre.
Yes, but brought under the one wing, your lordship. They have been brought under one umbrella, and now these two wings, at least up to the post of joint directors, they are shown, and above them there is a director. And Schedule 1A also clearly says that the post of joint director is for both the wings.
Mr.
And
Tongpok,
then below that starts the,
Mr. Tongpok, a service can have different wings, different cadres.
yes, your lordship, but that does not mean that one particular wing should be subordinated to the other wing. Here it is a clear case where one wing has been unreasonably, without any justification, without compliance with the requirement of Article 14. It must stand the test of reasonable classification, Your Lordship.
See,
And then that classification must be.
you must also be reasonable, because actually in the training wing, in some institutes, you have only one student, you have only 5 students. So whether you require a higher post for manning or for supervising 5 students, 10 students, do you need a post of joint director? What will be the financial implication to the state?
Your Lordship, if Your
I
Lordship,
think we have to balance all this.
if Your Lordship is going to consider all these aspects, and allow me to also submit how the employment wing is also. What are the functions of the employment wings? That is important.
No, those things are there on record.
Those things are there on record, and it is very clear that both wings, when it comes to assignment of duties and functions, they are more or less similar. In fact, it is the training wing which has more duties assigned to it, Your Lordship. And even the administrative reports, yearly administrative reports clearly lays down the kind of activities which the training wing is involved in, Your Lordship. But without going into that, Your Lordship, if Your Lordship is to confine only to the service floors, because even in their case, they are saying that it is based on the manual, national manual. No. Even in their case, it is not on the basis of national manual. Their national manual, they have not shown before this Honorable Court. I have annexed it in my affidavit in reply to the affidavit filed by the private respondents.
No, we will only have to consider whether the rules framed by the government violates your fundamental rights.
Yes, Your Lordship. If that is the case,
The government has the legislative competence to frame the rules. So
We
the
have.
only question is whether actually the rules violate your fundamental rights.
Yes, Your Lordship. That is the only question.
We have to actually scrutinize that issue on the basis of the rules.
Yes, Your Lordship.
Whether the rules violate your fundamental
Yes,
rights.
Your Lordship. Without going into the other aspects, because that is where this Honorable Court should confine. But since they have made so many statements which are irrelevant to the service rules, Your Lordship. So now,
And
I have to
what do
clear the
you
doubts.
say? What do you say? The rule shows both of you as a different class,
they are
as a different service.
two distinct classes, two distinct wings. It is not disputed, Your Lordship. I have never disputed that. All my, whatever the learned counsel for the private respondents have stated,
Everything is these are
Okay, Mr. Tong.
Your Lordship,
We have heard.
I leave it to Your Lordship.
So we will apply our mind.
Your Lordship.
And then, we will first.
Much obliged.
Yes. See this? Up to this. Push it here, okay? Where's this fellow, Steno? Heard Mr. Tongpo Pawana, the learned counsel for the petitioner, and MSB Sokre, the learned additional advocate general for the state respondents. Stop. Also heard Mr. Ajo, the learned counsel for the respondent number 5 to 16. Heard the matters at length. Judgment in order, reserved.
May it please, Your Lordship.
Yes, please.
I had mentioned two hearing items, item numbers 9 and 10. Both are separate matters, but I'm appearing in both of these items. Can these matters be taken up on 16th of October, madam, with the consent of members?
Okay. Mr. Lakam,
Well,
you are the counsel for the
IOCL, Indian Oil Corporation Limited. Respondents in both the cases.
and in this 291
Also respondent,
respondent.
all the respondents, both the cases.
In 91, yes, for respondent 2, 3, and 4.
It is for respondent
2, 3, and 4.
in 91. 2, 3, and 4.
Yes, ma'am.
One is pro forma.
And in 88 for the sole respondent or and another. Okay. Mr.
And
N. Borwa makes a mention. No. Mr. N. Borwa submits that. Mr. N. Borwa, the learned counsel for the respondent number for the respondent. This is item 9, na? Item 9. 6, adjournment of the case on
16th of October.
16, what is 16? On 16/10. On 16/10/2023. Prayer is allowed, listed accordingly. For item 10, Mr. Senso, learned counsel for the respondent number 2, 3, and 4. 6, adjournment of the case on 16/10/2024. Prayer is allowed, listed accordingly. Okay.
Good.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention hearing item number 11. Lordship, I pray that this matter be passed over for tomorrow.
You are the counsel for the
Petitioner, Lordship.
we will list it on 12th.
Lordship.
Oh, 12 is tomorrow.
12 is tomorrow, Lordship.
No, 18.
Lordship.
Yes. You are the counsel for the petitioner
Lordship.
on the prayer of MS Senso, the learned counsel for the petitioner, listed on 18/9/2023. Okay.
Pledge, Lordship.
May it please your Lordship.
Yes, please.
My Lord, supplementary item number 12, hearing. I beg to mention, Your Lordship, that it will take some time for me to get to. So if it is fixed in the last part of September, Your Lordship, I will go for my health checkup tomorrow.
Then we will release.
No, Your Lordship, then
If you go for a health checkup and by the time you come back,
after 2 weeks.
my constitution may not be there. Then in that case, what happens? Again, keeping the matter part heard for such a long time. Well, we'll list it as per your convenience, but we'll release from part heard, and if I'm there, I'll take up. If not, let any other judges, honorable judges, take up. Okay? Since you are going
I
for
also
checkup.
wanted that because since the matter is almost hard, my side.
Yes, but since you are going for checkup.
I also want that this honorable court should, if I.
Okay, you take a chance. When do you want it?
September after 25. For 2 weeks, I will come back, Your Lordship.
When do you want it?
26 September. Or 29, coming to the.
on the prayer of Mr. P.P. Paul, the learned counsel for the
Respondents.
respondent, listed again on,
29.
listed on 20, no, for 29 is Friday,
26 then.
listed on 26/9/2023, released from Port Hut. Okay.
My lord, interim order may be continued.
Okay, stop. The interim order passed earlier shall continue till the next returnable date.
My lord.
For motion, item number 1.
May I please, Your Lordship?
Yes.
Your Lordship, here the petitioner is seeking for direction to the respondents to release his monthly salary with effect from January 2021 till date, my lord.
RMS Swenso, the learned counsel for the petitioner. The case of the petitioner in brief is that he was appointed as W/C laborer within bracket fixed with effect from 21/6/1992 in the office of the subdivisional officer Pomching, under the establishment of the executive engineer, public works department within bracket R&B, Mon division, Mon Nagaland. Stop. It is the case of the petitioner that he has not been paid his salary with effect from the month of January 2021 till date. Stop. The petitioner has, through his counsel, served the legal notice dated 25/4/2023 to the chief engineer, PWD, R&B, Kohima, Nagaland. However, no action has been taken on the legal notice issued by the petitioner. So, being aggrieved, the petitioner is before this court. Since MS Livika,
All the respondents.
the learned government advocate, appears for all the respondents, no formal notice need be issued. Stop. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned state council when?
Within 3 days, my lord.
Within a period of 3 days from today. Listed accordingly.
Much right.
For admission, item number 2.
My lord, I have furnished the type copy with you.
Okay, we'll list it some other time.
My lord.
Today maybe we may not complete. When do you want? Mr. Anangami?
Lordship, any date convenient, Your Lordship, for this court?
Yes, give a date.
25/6.
Twenty-five or 26? Okay,
25, my lord?
yes. This is not a parted item, no?
It is released, Your Lordship. It was parted.
It is released,
It
no?
is released, my lord.
Okay. Due to paucity of time, the matter could not be taken up for hearing. For admission hearing, no?
My
For
lord.
admission hearing. Listed again on 25/9/2023. Okay.
Much obliged.
For admission, item number 2.
Please, Your Lordship.
Yes, ma'am.
Lordship, I have filed my reply to the state's affidavit this morning, Lordship.
Okay.
So pleadings are complete, Lordship. So if this matter can come up.
Whether actually it is on record, your affidavit?
Lordship, I filed it this morning, so
This
I'm not
morning.
sure if it's in the
This
file,
morning.
Lordship. Yes, Lordship, I have
Affidavit in reply.
to the state's affidavit, Lordship.
Affidavit in reply to the affidavit.
If it is this morning, then
If
it will
it-
be in the records.
MS Lucino, the learned counsel for the petitioner, submits that she has filed the affidavit in reply to the affidavit in opposition filed by the state respondents only this morning. Stop. The affidavit is, however, not on record. Registry to take steps. Listed after?
Lordship, if a date may be fixed for admission hearing, Lordship.
Listed for hearing in the usual course. Okay.
For admission, item number 4.
Yes, Your Lordship. I'm making a prayer on behalf of Tibapom, Your Lordship. Your Lordship, here he has not filed his counter, so 3 weeks time may be granted.
Okay.
May I please, Lordship?
Yes.
Lordship, this is a 2021 matter, so let us the last chance given to the government.
What is the matter about?
Lordship, the petitioner is praying for regulation of his work church service as handyman. The respondent number 4 to 15, their service has been regularized and they are all generated to the petitioner.
Okay. MS Inauli makes a mention on behalf of Mr. E. Tibapo, the learned government advocate, and seeks for 3 weeks to file affidavit in reply. Prayer is allowed, listed after 3 weeks. Okay.
For admission, item number 5.
Yes, Mr. Lordship. Yes, my lord, I'm appealing for private respondent number 5. My lord, actually I was supposed to file a counter affidavit, but since my
5. Whether the status file?
No, Lordship.
So both of you, affidavit.
Yes, 2 weeks time will be granted.
Okay.
Lordship.
Mr. M. Timson, the learned government advocate, the learned additional advocate general, as well as Mr. N. K. Luikam, the learned counsel for the respondent number 5. 6 for 3 weeks time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
For admission, item number 6.
May I please, Your Lordship?
Yes.
May kindly allow me 3 weeks time to file my counter.
Okay.
Lordship, last chance must be given.
Must be given. Okay. Okay. MS Inaoli, the learned government advocate, seeks for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks. Okay.
For orders, item number 7.
Lordship, I'm praying on behalf of Vijimo, Your Lordship. Here also,
No
he failed to
affidavit.
file counter, yes. So kindly grant 3 weeks time.
The learned government advocate is granted 3 weeks time to file affidavit in opposition. Okay.
Much obliged, Mr. Lordship.
For orders, item number 8.
May I please, Lordship?
Yes.
Lordship, I have instruction to appear on behalf of N.K. Morin. Lordship, the service report for respondent number 10 to 20 is still awaited.
This is 2019.
Well,
Oh. Who are 10 to 22? Mr.
It's a newly implemented.
Oh, newly
Yeah,
implemented.
implemented, yes.
When were they implemented?
16, 6, 19/6, my lord, and 2023.
19/6/2023.
No.
We give them one more last chance. After that, we'll see. They're waiting.
There was on the last occasion, the petitioner was also directed to include the state respondents. Here, the state respondents are not.
Why is the
They are
state?
challenging the SD and indigenous certificate issued by the state government.
Oh, that you have to implement.
Yes.
Where is Mr. N.K. Muri?
He's out of station now.
Okay, tell him to appear on the next date.
No.
Okay, so that we can pass necessary orders. Listed after 3 weeks.
Deeply obliged.
One more.
Notice issued.
4 weeks before.
Yeah. Notice issued to always 4 weeks.
4 weeks.
তাহলে